Yesterday I was telling for the support the paragraph.
You be here. You be here. Other
I'll be here.
Maybe the last
Here.
item 16,
Item
16, one thing. Some development to have file an additional affidavit. Right after. It's the next thing.
item 6 of today's list.
One thing, 16, right?
Okay.
But Friday next.
Friday next.
On Wednesday. Publish. Federal. I beg to mention item number
30.
2. May not
Okay. Okay. Please this be matter before any other bench. Yes. That will do. Any interim order or but it will be difficult for me to pass an order. Yes, there is there.
32 na?
City available. Okay. Do one thing after registry if possible today. Because there is an interim order case is there, I cannot take up this one. For production list. Have a talk with the registry. You follow it up.
Yes, sir. Please, my lord.
Item number it was
32.
32.
Please, my lord.
Yes.
My lord, I beg to mention for a urgent listing of a criminal petition.
Uh.
My lord, this is regarding a criminal defamation in the court below. My lord, the next date of appearance is fixed on 5th of December. My lord, may I pray that a matter will be listed on Monday, subject to lordship. I'm obliged.
Item number
15.
15.
18 मतलब city developer
What is the name?
FSL is
Okay. The learned public prosecutor submits the two case there is available. FSL is not available. Accordingly, he prays for some time. First prayer is allowed. Please this matter on.
मतलब 18 18
18.
of the
Case diary be returned back and be submit on
other item 44
item number
40 minutes on behalf of 44 on behalf of NDPS ACT has already submitted this deep but this has expired.
Okay. Have you taken consent for the others?
Yes,
When?
Any day.
No, any date will not do. His mother has expired. How do I know that when will be he free? Tomorrow, day after tomorrow, Monday. Then your specific ground is that his mother expired. How do I know that when he will be free? Yes, next.
May I please item number
Item number?
item number 32. Pray for item.
Yes. This is LCR. Okay. When? After 3.
May I please? I am praying for criminal petition regarding dimma of a vehicle. Any day of next week. 6. Okay.
Service is complete. Then wait for some time. Yes, next.
Yes, my lord. I beg to mention for listing of a criminal appeal. This matter has been written the last posted on June month. Any date on it.
What is the stage?
My lord is undergoing imprisonment, rigorous imprisonment of 7 years.
It is admitted.
Yes. For final hearing.
Well, final hearing. You that can be listed in the orders column. Then only we can decide whether it can be
Any
fixed
date.
before. You give a date for orders, not for hearing. Yes, tick mark the orders. No? Here, no hearing.
On both.
Item about 21. Any matter taken 2 p.m. 2 p.m. 21.
LCR, they will have to go through it. We cannot take up like this. So let it be called. Other matters you have time to go through, but these we do not know whether you have gone through it. So many. That's right. Today, these fresh LCRs will not be possible today. That is the mind of. We'll see when the matter comes. Yes. अच्छा. 64. Yes. Withdraw. 60. CD is there. You return back the CD. You want to withdraw that?
Back.
Yes.
As a person to the NPWM, I surrendered on 21/8. Now 439 FT is paid. Kindly request for today.
Today not possible. Monday.
Monday, my lord, I have accused them.
Tuesday.
And my lord, another pair of petition.
Hmm.
Then 2020 January matter.
Hmm.
And in this matter, my lord, the opposite parties appeared. Matter related to the path which connected my house.
Hmm.
Kindly, my lord, discuss this matter. Okay. Yes. Lord, I pick.
Item number?
Well, sir. Sir, what is it? I well,
Uh-huh. You want adjournment?
yes, sir. For a one.
For a week. Yes, for a week. For a petitioner?
Regarding item number 6, we have filed the additional affidavit
Item?
69. Writing for
Yes.
exceptional deputed and attempting bail and state safety. I pray, my lord.
Give a date, Muslimi. 8. 8. Yes.
The prayer for criminal revision
Service is complete. Are you not aware?
we have the second step.
No, you have taken step. Get the information from the registered company. Yes, next step. Tuesday.
Immediately. So that is a part
What is the stage admission order?
hearing. Edit it on the net.
Let it come on orders. We'll take it.
Happy.
Yes.
Happy.
Hmm.
Just five. Yes.
Manan, you be here for some time. We'll have some query in respect of your case that yesterday. I'll just ask you 2-3 questions. No, not today. itu kata semua okay semua you see this better it can be more going to register policy to the secretary of the secretary আপনি just করে
Happy to run.
yes
14 and 15.
scan copies
Good.
huh? But
Apply. Happy to run.
yeah
For FIR method, there are three education. Two are very good. 420 mile
did you interim
Exit number 1 method.
Huh. Yes, tell me.
On my lord, 19th of January.
Because my lord, oh, oh,
Yes, I-
Lord, item number 42 is also a connected matter
40.
to mine, where we have filed an IA in a
Yes.
pending 482 filed by the complainant.
42.
Yes.
Huh? Sir, Thakur, is this that same case that you have is it not granted bail? Call for the case diary out arising out of some motok.
So case is same, but the
No, no,
persons are
two
not.
parties there. One is that somebody represented them to be the government official, and then
No, we are not for all them, matter.
you are not. That
No,
has
we
been
have
done
for
by
a
Mr.
person
Mahajan.
who is a master astrologer, my lord. Only allegation which has been attributed to the petitioner before lordship is he introduced to the complaint. That's all, nothing beyond.
Now, what is the other criminal petition?
In the other case, what had happened, my lord, it's a case of illegal detention. The consequence of what it would be that I'll make my submission.
Hmm.
Now, there was a transit bail granted by a trial court in that. Based on the transit bail, my lord, we came here and we applied for an anticipatory. And in the anticipatory bail application filed before the lunch session judge, a notice was calling for this thing. And that order has been challenged by my learned friend client on the ground that once a person is arrested, how come you are invoking section 430? That is the ground. Now, what happens if the illegal detention is illegal?
Now we'll come to that
Yes.
later on. We'll come to that
Yes.
later on. Just before you argue, just let me understand, because I have dealt with a similar FIR, not similar FIR, arising out of the same transaction.
Transaction.
Same transaction. In that case, FIR was lost by you.
No. FR was lost by
Him.
my learned friend client.
You have lost the FIR where Mr. Bhuya appeared.
Yes.
AK Bhuya.
Yes.
Okay. So they lost the FIR saying that these people misrepresented.
Yes.
And introduced us to be the government employees and Motok committees went to Autonomous Council. Then some lady came before them, introduced herself to be officer, which still a fake work order was issued. That was in that case. Now, how do you involve in that case?
Yes. Now, what has happened, my lord? I am a past astrologer.
Hmm.
I am based in that.
Hmm.
I introduced
Hmm.
my only allegation in the FIR is I introduced to some of the persons. Nothing more than.
So this
And
is
in fact,
this
my
is
lord,
the other affair on account of the same transaction by the same party. This
Maybe.
is against you.
same FIR.
Same affair.
So, my
So according to you, this is the man who originally introduced the company with this man.
Yes.
That this is the money.
that is not this man, my lord. My lord will kindly come to the FIR. If the lordship would kindly take the petition, my lord. My lord, can I hand over a type copy?
That we require.
Yes,
That's
yes.
why all these questions I had to ask you.
I'm sorry.
And we do not know how registry accept this.
My lord will kindly come to page 9. My lord, we have introduced only one of the associate of the complaint, nothing beyond that. We
Page
don't
9.
even know the other people. Please come to page 9,
Yes.
para 2, my lord. On 17/9/22, Kuzdeep Bansal, that's the petitioner before lordship, induced, my lord, induced this expression, it has a definite legal connotation in criminal. Now, anyway, I'll come to the purport of this little later. Mohit Kalra, Mr. Rajinder Sharma and Kamal Sabharwal, that government of Assam is looking for supplier in bulk, which includes school bags, blankets, etc. for a project overseen by the CM for welfare of the people in the various districts in Assam. Kuzdeep Bansal claimed that he has good contacts with extremely resourceful officials at the top echelons of the government of Assam and can be instrumental in getting the project
a
for
minute,
them.
just-
Am I continuing?
No, just a minute. Yes.
He claimed that the contract value of the aforesaid commodity is 260 crore. He through WhatsApp also forwarded a snapshot of the requirement of the approved product and images of the approved product previously sourced by the government of Assam to Motor to other vendors. A screenshot of the WhatsApp message received by Mohit Kalra and Kuldeep Bansal saved in his phone as Kuldeep Uncle. Sharing the aforesaid information is expected here for ready references. My lord, this Mohit Kalra is an associate of the complainant. Kuldeep Bansal, in order to give further support to his assurances, induced his brother Haris Bansal, inducted his brother Haris Bansal, Kuldeep Bansal, assured that his brother he will manage the transaction from Delhi and will act as a go between all other accused persons so that no glitches or hiccups happen in implementation of the project. In order to have a seamless
Transaction. Seamless transaction.
in order to have a seamless transaction and further payments are received without any demur, he claimed that his brother would work in that regard. He also thought that his brother may be given some compensation for his services done. My lord, basically, this is the allegation against. My lord, we are not accused or alleged of introducing either Pallavi, one who impersonated as a government servant, or that so-called my lord MD, that part of what has been what. There's no allegation, my lord. These are the allegations against the present petition. I am based in Delhi. I am one of the very famous, my lord, Vastu astrologer in the country. Lot many people come to. I may have said, even if the contentions taken in his face value, does it, my lord, contain any ingredient of 255 or 472, my lord? Minus that I am supposed to get a notice under section 41. Now, my lord will kindly come to page number 22, my lord. Page 22.
Just a minute.
Yeah.
Now, how will you say in view of the statement it appear at page paragraph 4?
Kuldeep Bansal
These
on
are the
7.
statements. We do not know if it's correct or false. Specific statement.
Yes,
That
Kuldeep
this-
Bansal on 17th September 22 further claimed that he and his brother Haris personally know the principal secretary and managing director of the Motor Autonomous Council, the part of Bharat. It is now evident that Kuldeep Bansal was the mastermind behind the entire, as it was with him who was looking for victims to be defrauded and with aid and assistance of the other accused person. Evidently, it was Kuldeep Bansal and Haris Bansal who claimed to personally know Partha Bharat and also vouched for his position in the Motor Autonomous Council. And look, no, my lord, this bold allegation, lordship is correct. At this stage, to what extent lordship will go? I'm
Yes.
aware, I'm conscious of the legal. But if your lordship goes further to the allegation, my lord, this allegation stands, my lord, belied. Now, end of the day, my lord, what is the allegation against me? Am I responsible for issuing any work order? Am I
No,
responsible for
No,
introducing
you are not
to the
at all.
government
You
servant?
are not at all.
And then, my lord, am I responsible for, my lord, supply? Am I responsible for receiving the goods? And there is also no allegation that any money, pecuniary benefit has been
Now
given to
the
me
question-
or any pecuniary benefit was promised to me. Nothing.
Now question is that
Yeah.
nobody apparently has promised anything in your favor
Yes.
or something. But it may so happen from the face of the allegation. We cannot go beyond that.
So, yes.
That
At this stage.
you might be seems that a partner of this Bharadwaj and that lady, and through you are the bait. Through you, because you are having a relation with them. We do not know.
Yes.
We do not know. So I think at this stage, more particularly in a quashing petition, we can at best issue a notice.
No, my lord, what I'm saying, no, that asking of an order is a lot. prerogative.
No, it's not prerogative. It cannot be a prerogative. It is a
No.
decision on basis of law.
No, my lord will kindly
I may be
see-
wrong.
No.
I may be right, but it can. Judge is not
No, my lord
having any prerogative to pass any order. It like.
let us come to the bona fide and legitimacy of the complaint. Now, here is a complaint who wants to beg an award of 260
How we
crore,
know that?
and he has not uttered a single word regarding which tender process he has got to.
No, we know that. At that question you
Therefore-
asked, they should also be an accused in this process.
Exactly.
State of Assam should.
If at all.
Yes.
They are equally responsible, my lord. So, my lord, kindly imagine a contract of 260 they are aspiring to get crore, and this whisper about, my lord, a tender process.
So therefore, we are issuing a notice. We may expand this corruption naked to further by asking the CBI to investigate against all these people,
No, my lord.
including government
my lord.
officials.
No, my lord, regarding squatting and lordship will take note of, but my lord, some protection has to be given to the petitioner. I, my lord, will join the investigation. No, end of the
Protection you may consider when it's question of 438, not in a quoting of.
No, that's what the other petition involves that. Where, my lord, even my right to remedy has been taken in by an order of this honorable court, in respect of which I am seeking a vacation. Now, my lord will kindly come to page 22 for him.
Yes.
Last para. 1. From October 22 to December 22,
Just
the
a minute,
complainant,
paragraph.
my lord,
Page
1.
22.
My lord, it is in a very peculiar form, my lord. They are giving a particular heading, then they describe. In fact,
Are you not having this copy?
Yes, page 22.
I'm at page 22. It starts with inform, then it's
Yes,
paragraph 7.
last para.
Last paragraph. From the October.
Yes, yes. From October 22 to December 22, the complainant company made supply of total value of rupees 63.59 crore, a total of 10%. Now, my lord will kindly come to page number 31. Now, these are the allegations against that Partho and all, my lord. Now, pilot will kindly come to page 32, para 3. The accused number 2, namely Partha Bharat, was forged and fabricated the letterheads of the Motor Autonomous Transit, seal of the government, visiting card showing as the managing director, and also faked his ID card to prove his identity as an IS officer. The said accused also used a fake ID card of the Motor Autonomous Body to cheat the complainant who had believed him and supplied goods worth crores of rupees. He also used the fake letterhead of Motor Autonomous Body as managing director and competent person to issue purchase order to the tune of rupees 20 crore. So, the allegations are against somebody else, not against me.
No, that is
Yes.
correct.
Now-
Actual fraud has been committed by these two, that Partho and that lady.
Now, my lord will.
Whether you are in the conspiracy of the entire
Yes.
episode, that is the issue.
That is the only
And
point.
prima facie, in the statement
Page
of the
17.
FIR, it says that you are the person who introduced so and so for this purpose, and that you have vouched for their.
No,
thing.
my lord, my humble submission. There is a statement in page 17, para 4, which lordship has referred. I am not disputing the proposition.
Yes.
Generally, my lord, as long as there is a statement, at this case, lordship should confine. But when your lordship looks at the attending facts and circumstances of the FIR, my lord, that belies this allegation, my lord, because now there are specific allegation against these two persons. My lord, I am not involved in any wrongdoing other than introducing them. Therefore, end of the day,
That might be a story that we do not know. I know this
therefore,
man.
they will have to establish that.
You are also a victim of their fraud.
Exactly.
That may be. That may be
Exactly,
also.
my lord. Now, my lord will kindly come to page 37. Now, what is his grievance? Now, how lordship give a meaning to this para 5 at page 37? As on date, out of total invoice goods worth 63 crore, the accused person have received only 4 crore 43 lakh 50,000. Therefore, till date, an amount to the tune of rupees 58 crore are still due and payable to the company. So end of the day, my lord, it's a money claim which lies against the autonomous council.
If it comes, it is not the motor autonomous. Then where is the claim and counter claim?
My lord, though it, even in a civil transaction, there may be a criminal claim, but as Supreme Court said, I'm not disputing. Now, in the totality of these allegations stated in the FIR, my lord, there is no material even to, my lord, bring in that conspiracy theory. Where is it, my lord? Which is that material, my lord? Kindly appreciate, I'm a man having reputation. I'm a man person. I'm known in the country. Yes, many people come to me. Sometimes I may have said, I know these people, you can get a contract. When I say you can get a contract, I thought they will participate in a tender process. Kindly appreciate, my lord. Who is before a lordship with the complaint? Who is before the court of law before the complaint? A person who makes a contract without participating in a tender process. Now he is, my lord, becoming holier. Kindly see, my lord. All that I am saying is, lordship will definitely examine this. But lordship will, at least during this period, my lord, I should not be subjected to any coercive measure.
What happened to your
I'll
438?
participate, my lord.
What happened to your 438?
Now what had happened, my lord? Now, my lord will kindly take the IPC for a moment. Kindly have, my lord, section 255 for a moment. If 255 and 482 goes, my lord, then I am entitled to the protection under 482. 255. Counterfeiting government stamp. Whoever counterfeits or knowingly performs any part of process of counterfeiting any stamp issued by the government for the purpose of revenue shall be punished with imprisonment of life, with imprisonment of either description stamp, which may be extended to 10 years and also be life. So, my lord, there is no allegation qua 255, but the case has been registered under 250. Now, my lord will kindly come to 472 for a moment. Making or possessing counterfeit
472.
bill, etc., with intent to commit, 472.
Yes.
Making or possessing counterfeit bill, etc., with intent to commit forgery punishable under section 467. Whoever makes or counterfeits any thief, blade, or other instrument of making any impression, intending that same shall be used for the purpose of which should be punishable under section 467 of, or is such intent
Why this matter is listed before this court?
item number 42.
The bail cannot be
No,
listed.
it's not a bail.
Huh?
It's
It's
No,
not a bail.
other part.
No, that's
No,
not a
no,
bail.
not a bail, man.
That's not a
It's
bail. I
482.
filed an application of vacating a particular order.
No, that other matter.
That is one.
That
We
is
have
the
filed
other.
an IA
Okay.
for vacating an order.
Okay. He filed a criminal petition.
Yes, sir. I am in the petition.
Okay. I thought that was a bail
Yes,
and
yes. No, my lord, we also made a mention because this matter is already before to listed before lordship. So matter that they can
that
took
is
up with the rate, that is how it is. Whoever makes or counterfeits any thief, plate, or other instrument for making an impression, intending that the same shall be used for the purpose of committing any forgery, which should be punishable under section 467 of this code, or with such intent in his possession any thief, plate, or other instrument, knowing the same to be counterfeit, shall be punished with imprisonment or with imprisonment of either description for a term which may be extended to 7 years and also be liable to fine. Well, there is no ingredient of section 255 and 472 in the FIR, at least against the my lord present petition. And my lord, where is the allegation that I forced anything?
no. It is two allegations are not there.
Yeah.
Specifically
Yes,
that you have forced.
Against me.
Only question is that whether
There,
you are a part of the larger.
No, no, that is a different aspect, my lord. I'm coming
No, no,
to the
that,
bail
that is
aspect.
for the purpose, not coming for
the
the bail.
purpose of the question,
For the
that will be
crossing,
relevant.
that will be
Yes.
very relevant.
Now, my lord, I'm making my argument of the other matter.
Hmm.
Now, my lord, in that view of the matter, so they should have followed para 12 of the Ernest Kumar, giving notice under 41, which was not given. My lord, kindly see the manner it was. No, nothing, my lord. Kindly have a look at this IN. Please take the IN, my lord. For a logical for the moment, please have the passing petition. I'll refer to two orders, my lord, for the purpose of. My lord will kindly come to page number 107.
Yes.
This is the order, my lord, passed by the trial court at Delhi, whereby transit a transit bail was granted to the petitioner. Kindly see, my lord, accused has been arrested during a raid from Nebisarai in connection with the present case. A cheating case is pending against the accused. Accused is thus required to be produced before Learned Sizem Guwahati Kamrup. Lord will kindly mark this word. Learned Sizem Guwahati Kamrup, not Metro. At this stage, Learned Counsel for the accused filed an application seeking grant of bail application. It is stated that the applicant is innocent and falsely implicated in the present matter. Applicant is a respectable person, has an utmost respect for the law of the land. Applicant is permanently residing in a aforesaid address and is no likely to applicant taking a step which should be prejudicial to the fair investigation of the matter. A civil dispute between the complainant and Motok Autonomous Council having given a criminal color to settle personal grudges against the complainant. Applicant is not even remotely connected with the alleged offense. Applicant accused undertakes to join proceeding before the court before application may be allowed. Inspector Profulla Soike opposed this application, submitting that the accused is deliberately avoiding the proceeding in the present case. It should not be granted any relief as is likely to indulge in such crime if enlarged on bail and free from justice. Neither any notice, no intimation, nothing was given. Submission heard. And see, it is seen that no warrant of arrest has been issued against the applicant accused. Inspector Profulla Soike does not have a case diary and IO is absent to clarify the same. See the violation of the court, my lord. In view of the above, and taking note of the fact that Learned Counsel undertakes that the accused shall remain present personally before the concerned court within 7 days, therefore accused is admitted to transit bail for 7 days and furnishing bail along with. Then my lord will kindly come to next page 109. Same is considered except with direction to the accused to join the proceeding pending before Learned CCM party. Then my lord, and my lord, admittedly, no proceeding was pending before the Learned CCM's court. And there was no notice either. Then my lord will kindly come to order dated page 110. This is the bail application I move before the session just. This is the order. I am reading the sub-para, my lord. Learned Counsel appearing for the accused petition has submitted that accused petitioner was arrested by CID on so and he was allowed transit bail by the. Right? It is submitted that accused has given 7 days time to appear by furnishing a bail bond of 50 rupees, 50,000, and 7 days will expire tomorrow as such may be allowed by interim PRS bail. On the other hand, Learned Counsel appearing for the complainant has opposed the PRS bail prayer of the accused petitioner. The IO of the case has also personally appeared before the court and has filed objection in writing against PRS bail prayer. Peruse the bail petition along with the copies of the document and the objection. Interim PRS bail for accused petitioner is not considered is called for the case diary for consideration of PRS bail. Well, this order has been assailed in, my lord, the other connected matter. My lord, admittedly, my lord, no proceeding was pending before the Learned CCM Kamrup. So, my lord, the question of we inquired to find any proceeding, my lord. Therefore, the question of approaching CCM Kamrup did not arise. Admittedly, no proceeding was pending in that court, my
FR registered where?
maybe Metro, my lord. My lord, we have not received anything, no intimation. My lord, the IO is not present, city is not there. Then my lord will kindly come to the our application, where we have assailed the order passed by the Honorable Court on 31/10/23 at page 14 of the other matter, IA. Page 14 matter. Now, gist of the argument of the other side, Lordship can notice that page 16. Page 16, my lord, para 5. It is averred that learned trial court failed to consider that opposite party number 2 was granted bail subject to the condition that he would appear before the learned CJM within 7 days. The petitioner has prayed to set aside and quash the entire proceedings of AB number 32 as so and so. Petitioner has relied upon Gurbakh Singh CBI. Now, my lord will kindly have that. Fifthly, the provision of section 438 cannot be invoked after arrest of the accused. Grant of anticipatory bail when accused is under arrest involves a contradiction in terms so far as offense or offences for which is arrested are concerned. After arrest, the accused must seek his remedy under 438. Well, I can appreciate in a legitimate exercise where the arrest is lawful. Yes, this is the correct proposition. Nobody is disputing that. But in a case when the detention is illegal, then what happens? There the Supreme Court has taken other view. If it is violative of Article 22(1), if it is violative of Article 41(b), if it is violative of Section 55 CRPC, then it will be an unlawful arrest. In which case, my lord, I cannot be prevented from approaching the jurisdictional court for seeking 438 prayer, my lord. And that is what I did. And this honorable court eventually, my lord, at page number 18, my lord.
118.
Page 18, para 8. I have considered the ratio decisions in case of so. Para 9, petitioner has drawn out sufficient ground for stay of the order passed in so. Where is the discussion? Where is the conclusion reached by the learned court, my lord? The court defense of this honorable court, that here in this fact of this case, these are the facts, these are the principles of law, and therefore, my lord, I am taking this particular view. It's absolutely cryptic order, my lord. And today, my lord, can I be remediless, my lord? I can't go to any court because of this case. Therefore, my humble submission, Lordship will hear the matter by issuing a notice in my criminal petition. And my lord will meanwhile protect. Prima facie, my lord. Prima facie.
Yes, PP.
And one second. My lord, a non-bailable warrant of arrest has now been issued. So I am taking some protection with respect to.
Yes, PP. Okay, have it. We are taking after some time. Don't take this kind of technical thing. We are giving you the copy. Please be fair to the court. We do not appreciate this kind of technical. You have a copy. Go to it. We'll take it after some time. No, you have it.
We'll furnish a copy. No, lord.
We'll take it after some time. Let him go to it. Have
Yes.
it.
In the meantime, Lordship, can I start?
We'll hear you. Explain how can without IO, without case diary, it will may amount to an arrest. We do not like police high-handed. Forget about other things. Yes, next.
And
We'll come back.
Can I start?
No,
In the
we'll
meantime.
come back. We'll first give the audience to the public prosecutor, then we'll come.
But that is the arrest, not, it is an arrest by the, only on the basis of the fact.
We'll come back to it. Let the public prosecutor tell us what they have done.
Okay.
We'll come to you later on. You are the informant. On the basis of information they have acted, let us see how they have conducted. Yes, next. You will point out whatever you like. If you necessary, you have a talk with your IO and come back after some time.
may I please the lordship, madam? Here is that both the petitioner, husband and wife, they married, my lord, and thereafter, after their marriage, my lord, family members
Which
have,
marriage is earlier?
madam,
Which marriage is earlier?
my
You
marriage,
with you or the other person?
no, there is other person.
It's an anticipatory bill. City intent. Within 10 days.
view, it's still
On the
Yes, next.
the it is not part of by IO. According to it is ready to appear before the IO. Not
Who are the other people?
other people, Otisma Theory and Vivek Gupta already get bail.
City interim.
UBI.
January. Appear before the IO.
Apply.
City. City.
both are good and bad.
I know that. City at the early death.
Two mark.
Huh?
Boxoy there.
Nalbari
Always there.
19.
90 in the midnight. If the
Two
Respond number two.
mark.
Both ways. But we are also keeping a permit. Yes, this matter, one, his girlfriend is arrested. Is that it? When the matter is fixed, we take up along with
Diganta.
Not FIR, but
not
already-
specifically named that you are along with her boyfriend.
no.
How do I know that you
That
are the boyfriend?
That boyfriend arrested and already
Was the dead boyfriend arrested? You are
arrested,
different
already
boyfriend.
granted bail.
Okay, interim.
This is 14. This is
16
11.
on 11.
11.
Yes. Yes.
May I please?
Hmm.
But before going to the fair, before your lordship to come to the fact of the case, there are three.
City interim. You are the landlord.
I'm the land.
City.
But a date.
Date definitely.
In
January.
January.
10 days. Recorded.
Oblige.
Case diary. Forgery has also become civil list. That this salary is not executed by me. It is a fraudulent salary. Number is given of such and such. And actually, this is not the salary. It relates to something else. These are civil disputes.
That's true, Lord. But
If that's to city.
Lord, filed and sent the mark type.
Hmm.
And in the detention, they have not taken any plea.
Hmm.
They have heard it at November.
Where is the suit?
Plain Miller is annexed the Miller, page number 31, the plain
Page number
31. One when Parali filed a suit against the government and they have filed a when Parali filed a suit for part of it. In the suit, they have appeared, informant and brother
What
appeared.
is the suit? So you are dependent.
Yes, sir. I'm the defendant number 3.
Now what is the case?
Here, human Parali case
That Dipjyoti and Parag Jyoti has entered into an agreement.
agreement for sale
Agreement for sale
with the Hemen Bharat.
with
Hemen
Hemen
Bharat.
Bharat. Now you are the
I'm the defendant.
no, you are the defendant. What is your role in the? What is the statement allegation against?
No, I allegation
No,
against the
you
against
are Depop.
Yes.
You are Depop.
So
Why you are made a
that
party
part-
in the suit? What is the allegation statement against you in the
allegation
what is your role attributed in the execution of the agreement for sale
there is a gift deed in favor of the
gifted in
favor
favor of me.
in favor of you? Now, how it is related to the present suit property?
But it for the pilot, deputy and productivity purpose has gifted me the 7 letters of that,
Okay, then
which is registered gift.
okay, then
Then my lord, deputy and productivity in the year 2020, they have alleged and executed it for agreement for sale, which is placed. Thereafter, my lord, deputy permanent productivity executed any step, they haven't
now what
filed
is
it.
anything against you in the plain?
if the portion of the land already gifted to him, my lord, then how it can be for agreement for
Okay,
sale?
that is there. Now, where is your gift deed? Now, fraud in respect of which document?
But they have
Fraud in respect of which document?
Lord, there's a gift deed. In fact, February,
You are the beneficiary of the gift
I'm the
deed.
beneficiary of the
You are the beneficiary of gift deed. Allegation is that gift deed itself is forged. Forced by whom? You.
Yes.
Who says that?
Lord,
Deputy.
the donor says it. So before that, if your lordship takes up page
I am at page 31.
31, one
Plaintiff Hemen Bharali files a suit for specific performance of a contract against Dipjyoti and Paragdyoti.
Yes.
Dipjyoti and Paragdyoti, his case is that Dipjyoti and Paragdyoti entered into an agreement. However, subsequently he executed a gift deed in favor of the default.
Yes.
Now, who alleges that this gift deed is forged?
deputy. Now, interestingly, my lord, deputy files his written statement in this book, and he takes up a very vague plea. He says my intention was not to give. He doesn't say my signatures are false.
City intent. You want to say both might be in collision.
I have that is my
Okay.
Obliged.
City intent.
Tanmak.
Yes. Go to the LCR. No, we know that. Wait a scan copy. It's here. Just go to it.
We have to go.
Scan copy that not today. Next week.
Right.
Okay. The scan copy call for has been skipped. Learned public prosecutor as well as the petitioner is permitted to go to the same and let the matter be listed. Give it. You go to it. The file is here today. You go to it. 10 also same. Same order.
Has come.
Come. You go to it. Press scan matters. Let them go to it, and we'll take it up next. We'll take the other method. Finish up all the other methods. So already these are pending. These let them go through it. Again, we'll take up it the next week. Go through it. Public prosecutor, like the other cases, you go through it and
It
it will be here. No, it not immediately. You send the orders here. They will keep it here. They let them go through. You ask your junior also to go through it, but
On tip.
on
11 also.
same. 11 same. 12 and 13 adjourned.
12.
Same means they will go through it. LCR is there.
I know.
We'll take it up on 5th or 6th.
last time it got to solve for whether I was examined or not. Out of 11 witnesses, 8 have been examined. All the 5 witnesses were examined. Whether I was
It is a POCTO.
that is Lordship has seen the case. It was case, otherwise everything is complete. But
50% on 22/11/2023. accordingly list this matter on
Not it. But
tell us
for
14. In the meantime, register to a reminder requisition the same in terms of the order dated 2011.
but sorry, I not this.
Yes. Item 15.
What type?
It is
It is.
there.
What type?
Timing today we do not know. Moment will go to the NDPS, it not come. Oh. This is AP.
PA.
Take up
PA
PA.
PA.
What is the offense?
22 C lot.
Huh?
NDPS 22.
NDPS. How many days? No search sheet.
125
How many
days.
days?
125 days. 125.
125 days. What is the stage of investigation?
But other investigation is a progress lot. So FSL lot.
Only FSL is there.
FSL receipt lot.
Then what is the problem in fighting the search sheet?
The positive
Next week.
Four 39 application of the FIR lot by page 13. That was covered for the position of the petitioner.
Healthcare receipt. Okay, next week. Go to the yes, Kotapur and Kolkata. Go to it.
What is CD not received?
Huh?
CD not received.
What is the allegation?
Three 65 and 370. Foxo lot. It's a Foxo.
It's very call for not received. When?
From Bongaigaon lot. On 15.
Like how many days? More than 90.
That I have not counted.
Okay, she was shown to be arrested on 24/8/2023.
24/8.
8, 9, 10, 11. Today is
Today is
from the forwarding report, it's seen that the petitioner has been in custody for almost 90 days. Huh? For how many days? Chief Minister expected 90 days. 90 days. In as much as accordingly the petitioner is entitled for all point. The matter, I think it is not paid. To the satisfaction of CM Pujai, Concordate number. CM 25. Healthcare conflict. Yes, go to the LCM. No, I can see right. 13. Healthcare. This is item number
20. It's the intermediate, but the for the of journal to go. They submitted
I'm
13
not
without
getting anything. This
MCM.
matter, all cases are listed. listed in some other court, it gets adjourned and it comes to this court.
Similar kind of
Every cases and other benches are also taking up the same method. Next week. Give a date. Both people.
But for 39 applications, page 58 days of the offense got to 21.
Matter is 6 and 612.
58 or 60 the
Mandatory intermediate.
yes, 21 page.
21B. Now, how many days do I have?
58.
no, we'll take instruction.
It is there.
It is not here, madam. We have
You have an instruction
Yes.
today. What your name?
Or possibly both are 20 years of age. And can you see, my lord, from her account it was sent. When we had a bad stint of relationship, she herself sent it because she was in a relationship with a
Where's
different
the
boy.
affair?
Now, well, affair is a page 11. From her account, when I was having teen days, my lord, occurrence is of 6-9, affair is of 4-11. And he was arrested the next day, my lord. From her account, my lord, that too, when they had a my lord, adverse relationship. Can it after message and phone call? How can I catch hold of her Facebook account? Passport and everything to be with her.
Out of love, I'll give everything.
30 days it cut. Both are 20 years of age.
Where do you get your age?
Yes, yes, in the forwarding report. The forwarding report. With all respect, that is just page 20, my.
It is there.
It is.
Our statement is recorded.
Not
Huh?
Not recorded.
No, he's not. That's all.
161 recorded, 164 is not.
Why? Any
I
explanation?
have not found any note regarding that.
Who are the other witnesses? What is the medical test?
Medical is also not here. And regarding
Possibly
Yeah.
I not I must say
I thought, regarding actually they went to a hotel here.
Considering the
Hello,
case
kindly.
for this period,
Just last note and paper. That would be the
Last?
that last two
yellow mark.
things. Okay.
Considering the method of litigation, material available, materials so far collected by investigating authority, and also considering the period of detention, which court is of the student, no further record allowed to go on bail to the satisfaction of
What is CTM Lakhimpur?
CTM locked.
Highly obliged. Obliged. The 26 DD not it.
When?
I think that temporary interim is there. It's
Interim is there.
I thought
Oh, yes, interim is there. January 11th of January.
matter may taken after. But matter may take
Matter may be taken up.
after.
Is the multiple?
What is that?
438 application.
Where is the affair?
After your lot, 8 matter, 12 matter.
The affair is a page.
12 matter, 1.
Yes, sir. Give the statement, victim statement.
Yes.
I am on behalf of my lord, accused number 1. And my lord, we have paid the informant as a party.
You are accused number.
1, my lord, Umar Ali man. Umar Ali man.
You are accused number 1.
1, my lord, Umar Ali. And one more, whether this
Yes, that's it. Yes.
for that matter, it later 70 matter. Whether 438 application I that step after judgment of High Court. Paragraph 6. 6 and 7.
Paragraph
6.
fine.
It's not my back.
Who filed it?
The informant.
Who is the informant? will proceed against the informant. If
Yes,
yes,
but not the,
will proceed against them.
Yes, yes.
If he supported your case.
Yes.
Will
I have not. It's not the proof.
how can, and I ask you to investigate that under what circumstances the information is filed. Yes, this is not done.
Yes.
Special investigation will be done.
Yes.
Under what circumstances this 11-year guard,
Prepared by the file in a pipe.
are you on interim?
Yes, sir.
Case there is there?
No, my lord, 28 case there in active.
When?
He is on interim, my lord, on 19th of January.
19
Interim order.
interim to continue.
Twenty-nine also, my lord, case there in office.
Interim is there?
Look at.
Huh?
Look at it.
No.
You got the type.
Ah.
But let's to type it.
Ah.
That was not what.
Regarding that, my lord, I have nothing.
Then why are you put?
But there is a difference.
No cases you have that Mr. Kota could submit that you will obtain the instruction whether any case registered against the present. So it so an allegation is made that police are charging the present. Please, in the month of January.
Yes, right.
Give it. 19 January. Interim order passed.
Publish.
Currently, speaker is not working or what?
So here offense is registered under, my lord, section 379, along with rate with, my lord, 13(1) and 14 of the Assam Cattle Preservation Act. He is the owner of the cattle. 35 numbers of cattle were recovered in that truck, out of which, my lord, 4 found dead, my lord.
What will you do with his doctor? Here before the I dead.
31 and 33, my lord, same FIR.
Order 365. FIR is 11 years. Number 31 is not named in the FIR, only related to that 33 matter that was
Paragraph? No, come to
page 11.
Page 17.
Page 11.
Page 11 is a translation.
Oh, yes, yes.
We will not see.
Yeah, right. Sometimes I also found out sometimes.
So number plate Bolero.
Bolero belongs to my brother,
Bolero belongs to your brother.
my brother. And it was the new car, my lord. Just my lord, it was purchased and was taken by one Sahido, who is item 38. In fact, my lord, Sahid and informant has some monetary transaction.
Is it also Google Pay?
Google payment. That,
Huh?
my lord, slip is also available. You have 50,000
Google
in the
Pay.
account
That
of
to my
Shahidul
information, my lord, that the moment he was to pay money, man. That some transaction that he paid to Google Pay, not because of this transaction.
is Shahidul Ali, my lord.
So
Item
that is
number
item I am not.
Google Pay to whom?
Shahidul Ali. Is, my lord, in petitioner item number 33.
Item number?
33.
And who is the
The present accused, my lord, already in the note of the IO, that is, my lord, the vehicle which was used at that point of time, at the time of commission of the offense, that vehicle is of, my lord, one Dilwar Hussain and Aftab Hussain. That is the note of the IO.
so he is Dilwar?
No,
He is
I
Aftab
am
Hussain.
after my brother. It belongs to my
Now
brother.
police is
Dilwar.
searching for
I was not present even, my lord.
FPR before the
Yes,
one Dilwar and Aftab we are for the timing.
probably
only
that
Aftab before.
Huh?
Not Dilwar. Only Aftab.
Aftab we are giving interim returning back the city and come back. We are not making it actual.
Yes.
Let us see what are the so far relating to this. Who is this? Sahidul.
Sahidul.
Item number?
33.
Oh, here.
Yes, Sahidul.
What?
Yes. Google Pay. Very nice. If you are not having money, pay to
money for me.
Ah.
But they have been
vehicle belongs to your brother. Now, how he could take this vehicle, position of this vehicle? Who gave you the vehicle?
same village here, but you pay
So you will take others' vehicle
No.
and go to
for the
go-
relative, go to the relative, and return back, found here, selling petrol or something.
informant was selling petrol from your vehicle.
No, yeah, for the tanker.
Okay.
One thing illegally come out.
So you say that you are selling the petrol. So give us your
No, no.
50,000 Google Pay. Somebody selling the petrol. Inform the police.
The thing. We have took money from, we have transferred this year. Yes, the driver,
So driver is taking 50,000 from owner.
6 months. After
All boleros, number plate, not only this case.
Right.
In Sanctuary
it's a new
and at
vehicle.
the middle of the night,
It's a new vehicle. Not
and
the-
you will all this without number plate, and you will say that you are somebody will say we are police officer. We want to take, then say pay Google money. Not only that, that railway traffic, even contrabands were released and payment in Google in a pawn shop.
After 2 days of the incident, this FIR lost.
Don't use Google. This time, don't use. Sahidul stands rejected. 33. And then what is the other one?
Item 31.
After interim, considering the nature of allegation, interim
25th of January.
on 25th of January, appear before the IO within 10 days, and if return the case diary, if it will produce the same on the next day. This is in Aftab
Item 31.
Hussain, item 31, AB 3861. Okay, and AB 3899, Shahidul Ali reject. Case diary return.
May I please proceed?
Yes.
Yes, my lord. If we have a look at page, my lord.
Kindly discuss about kindly possible for the time being.
Right.
One is APP, my lord, MP Goswami has gone for the case.
73.
Yes, my lord, he has come.
Yes, Pushpa.
Item number 70.
My lord,
Yes.
in this case, my lord,
Hmm.
just after registering the case, my lord, initially police has arrested, my lord, 2 persons, my lord.
Hmm.
The 2 persons has been forwarded, my lord, and the 2 persons' name is, my lord, in the forwarding report, that's my lord, in page 12, my lord, page 12. Imtaz Ali, bottom of the page, my lord, page 12.
Who was the first FIR? Page
First.
9.
Yes, yes, my lord. Page 7 is the affair, my lord. Page 7.
Page 9 is the FIR. Page 7 is a type.
Yes, the type copy, my lord. Original FIR is, my lord.
Okay,
Page 9, my
okay.
lord.
Then,
And hereafter, my lord, there is no name in the FIR, my lord. No one's name in the
okay,
FIR.
understood.
However, my lord, the police has arrested, my lord, two persons, my
Hmm.
lord. MD
Imtaz
Imtaz
and
Ali and
Mafazil.
Mofazil Ali, yes, my lord.
Hmm.
And I am, my lord. We are, my lord. One Jomir Ali and page number 2 is my son, my lord.
Why
That-
do you apprehend?
Yes, my lord, recently, my lord, after long gap, my lord, the FIR has been registered in the month of, my lord, March 2023, my lord.
Yes,
And
what is the,
recently-
why are you searching?
Malat, yes. No, Malat, no, no, here it is available.
Yes, yes, what is the,
Malat, police, Malat, when the ATM vandalized, Malat, police seized one gas cylinder, gas cutter, and other things, material. Appearing that this is a fabricated shop, Malat, that 2% arrested.
Hmm.
And that there is a vehicle. This Malat, father is the owner, and along with this one, Malat, a vehicle is also involved to bring out that ATM. Malat.
okay, that ATM
So-
was,
It's supposed to be taken by that vehicle.
is the vehicle owner in which vehicle that machine was taken?
my vehicle is, my lord, my lord, taken by the police from my house, my lord, at my address, my lord, and there was nothing, my lord, nothing recovered. In the vehicle, only vehicle has been seized, my lord. There was nothing, my lord. Whether any materials were there inside the vehicle, my lord, that has ascertained, my lord.
Suppose you use the vehicle, all of
Yes,
My
but,
lord,
my
so-
lord,
police,
after-
police,
told
police,
that machine.
and
Then
all this, my lord, otherwise vehicle recovered, but
any materials that
No.
he is having antecedents, he is
no,
involved
my
in.
lord, police,
Normal.
my lord,
They might
only-
have taken the vehicle on rent.
Yes.
Also.
no,
If any indication that he is also involved with this
my
other
lord, as per the IO note, my lord, they are also involved
Involved.
in this search.
what are the statements of other may not be necessarily important on the basis of
Malat,
co-accused, we may not.
No one state their name, my lord, because they are searching. But police only suspect of the vehicle, my lord, vehicle
Okay.
of the person.
Allowed.
Obliged.
Yeah, let them.
Master,
Regarding
I will
but
appear, my
ATM machines, my lord,
lord.
No, we
I will
understand.
cooperate, my
But if even there is no statement by the co-accused, we know that co-accused, the value of co-accused statement.
no, no one is that co-accused said that our gas cutter machine has been stolen and by some person. Who are the some person? Maybe these two person because that
They say,
yes, my lord. They are the owner of the shop, the fabrication shop, my lord. Their gas cutter and cylinder has been stolen by someone
so why have you arrested them?
because the gas cutter and cylinder of their shop. Subsequently,
But you have, if it is stolen, you have not found that in their possession.
no, not yes.
So you have arrested them.
Uh,
Now, on their basis, gas cutter stolen. Now
No,
you
no,
have,
that regarding the clue is regarding that vehicle.
there is nothing on CCTV.
CCTV is not there, but
No, it says there is a CCTV. From that they saw that this was taken. See the affair.
my lord, yes.
Kindly come to the affair.
I have FIR, my lord, but CCTV
The
footage.
allegation is that
Police got the information by the number of the vehicle that he said owner and the mother.
the record has not damaged the lock of the shuttering door of the ATM. But there is not that it has been taken away.
No,
The ATM was attempted to
yes,
vandalize.
it's supposed to be the case.
Ah.
No,
But
door and
that
shutter
vehicle
all,
is used. From where have you got it that this vehicle is used? Any material, tell us. That any indication by any witness, any CCTV that this vehicle was used in that attempt. If nothing is there only because the vehicle belongs to them, they are near this.
Obliged.
details.
Obliged, my lord.
That is the invest purpose. Otherwise, my vehicle inside my house, nearby my ATM is stolen. My vehicle, since I am having a
No.
vehicle, something must be there, linking.
Thinking,
Yes.
my lord.
Anything, any suspicion. We are not saying that we are convicting on in a bill. Something must be.
Obliged, my lord. Master.
Yes, Prabhuya.
It is
Huh?
70. FIR is based 10. FIR takes 17. Prior to that, I contact
It is not here. It is not here, Mr. Where is the FR?
FIR is based 10.
Who are you?
I am Procedural
Topojul.
and other second petitioner is my wife. Other support my son.
Your son.
Not having a process of I have at Morigao and 2, 3 and 4 helping me in the job. 5 is the that I filed a complaint against the informant that is page 18. Informant and her that was filed on 25/7 to FIR is filed 17 2000. The counter draft was I am well established.
How you can promise of giving any related to the Gaupura and all? What is
That is
this?
totally it is a counter
My lord, family.
You are?
because I filed a complaint.
Oh, counter forget. I am asking why people will believe you that you will give the allegation 1 crore rupees and get the signature. What is it?
My lord, my lord, family kind of business because my lord, the father says my lord, he is a team and his wife is ADC and his son is a my lord, official of my lord DC office my lord. In this way, my lord, they say that we have every connection. So the poor people my lord, they believing that my lord, they will
Now
get
they belong to which village?
my lord, village.
Huh.
My lord,
Suppose I know my neighbor. My neighbor comes
yes.
and says me that I am Prime Minister
it's
of
my
India.
lord, the village Boribari. PS Safari.
So they are neighbors, and neighbors will come and say, I am the Deputy Commissioner of Borpeta
All
district.
the
Give me this
all
money and I'll sign it. Will that
here,
idiot believe?
my lord, and here my lord.
Tell us first that informant and the accused belong
lord,
to the same village.
No, my lord. Informant, these accused are from village Katoni, Gorompura, Lahori Ghat.
And the accused?
And other, this is the accused.
Accused
and-
are related.
Yes, and
And what
others,
is the
my lord,
informant?
others are from the village Boribari. That is separate.
What is your earlier complaint?
Page 18.
Page?
Page 18. Opposite to who is the husband of the informant. 5 informant from
Interestingly, my lord, all the my lord, beneficiaries, my lord, the victim beneficiaries, they are not from one village. But spread all have given that.
for last 4 years for take it time. No, nobody has submitted any complaint in the village. Since I filed the complaint against the informant.
What is your complaint dated?
Complaint is 25/7/2020.
And what is the FIR dated?
FIR dated 17/10/2020.
Oh, this case. How do you believe that it has been received in the Deputy Commissioner? Huh?
Yeah, Lordship,
What are the
Received,
victims
Lordship.
says?
Lordship,
Victim
last
says, my
complaint
lord,
was-
Forget about this informant.
yes, no, other victims also, my lord, implicating them. That they used to say that he is a deceased and his wife is a victim. So in this payment, they collected some 75 rupees, 75,000 some from someone, from 35,000 from someone in this payment. And my lord, the complaint is from
People are saying that they say,
Tengaguri.
somebody will come and say, Deputy,
Not
we can understand Mr. Chud, Omtuan Bora's client, that
Yeah.
hundreds of crores.
Yes.
Somebody will come and say, I am
Yeah, well,
deputy, I am secretary.
And it is that is what is the case, my lord. And it is some separate village, my lord.
And another one, he's also from one Tengaguri village. All are from different village, and they were
analogous
cheated.
village.
They were
That is
cheated.
analogous village. Even stated in my
Neighboring village.
Dori
What
Bori,
is analogous?
neighboring
Dori Bori.
Village cannot be analogous.
neighboring
You are doing education cases, you have made village also
Soil.
analogous. Huh?
neighboring.
Amalgamated. Village amalgamated or what?
No.
Yes. I know. We'll see that case back.
Yes, sir.
Except the complaint, and nobody has filed any complaint.
We are concerned
Like,
about
well,
the,
We'll see
established
the
committee.
Peter statement, how
Only-
they have.
No,
Okay.
concerned
We
about
are
the
coming back, then we'll take Mr. Chaudhury's case, K.N. Chaudhury, and inform for our. Okay, we are coming.
Lord.
After 5-10 minutes. Mr. Fukan, when is the next date fixed in the other case? Call for the case date.
in one case, your Lordship already been bail rejected. That ought to be sufficient. Your Lordship has rejected.
After perjury,
Yes,
it is
after
rejected or you call for the city? I have rejected.
Rejected. My Lord, this is the order. After bail rejected.
Okay. Now, what are the allegations as such in this affair against this person?
My Lord, he is the main.
Which are the paragraphs where involvement of this petitioner is alleged? We have seen a paragraph,
Kindly peruse your Lordship, criminal.
paragraph 2. No. Yes, what have keep the copy?
Lordship go by pages because every time there is a
Okay,
sub-para.
page 9.
My Lord, kindly be, my Lord, the criminal petition 1186.
I'm here.
1186 petition, kindly page at page 30.
1186. We
My
are
lord,
in
yes.
157.
Kamal Sabarwal. 1184.
No, item number. Tell us the item.
Item number 42.
49.
42.
49 is the other petition where you have filed IA or what? Yes. Okay, keep the copy. Are you having a copy of it?
My Lord, yes, I have got one, my Lord. Here, actual, my Lord, FIR is here, man. In this case, my Lord, page 30, man. Criminal petition 1184 of 23. Kamal Sabarwal.
Readable?
Yes, it's readable.
Yes, that's my petition. Okay, that is your petition. Criminal petition 1186. Page
Kamal Sabarwal, my Lord. Yes, page 30.
page 30.
My Lord.
Okay.
Yes, your Lordship. May I read you? At page 30, my Lord, the para 1, my Lord, the present complaint is being filed by the Messrs. Sabarwal Trading India so-and-so, duly registered company under such and such act, having registered office of such and such, your Lordship, and the Mr. Kamal Sabarwal, before your good office, seeking registration of the FIR against persons, namely Sri Kusdeep Bansal, my Lord, the present petition, and the other accused.
I will not go to other for the time being.
My Lord.
Now we want to see the statement against this petitioner.
My Lord. And my Lord, page at 31. Company turn page 31, serial number 4.
Serial number
4, page 31.
What
The
is one?
subsequent paragraph will broadly online the modus operandi and the broad subheads of the illegal of the accused. Here, my Lord, the Kusdeep Bansal, the present petitioner, his brother Harish Bansal, Partha Bharadwaj, and other accused person induced the complainant and his associate into believing that the work assigned was a government contract, and they also actively participate with each other into interrupting them in a elaborate scheme of a fraud forgery. As a result, the complainant and their associates supplied a huge consignment of goods
It now transpired that the entire transaction was an elaborate scheme of a fraud wherein the name of the top functionary of the state government of Assam, including the Honorable Chief Minister, was used. Forged and fabricated seals and documents of the Assam government were used to give authenticity to the deceptions, resulting the defrauding of the complainant vast sum of money. They conspired with each other and impersonate and create a false impression that the accused number 2 is a Assam government functionary and was entrusted by the Honorable CM office to execute social welfare project. In order to further their objective of cheating by personations, they fabricated and prepared a false document of Assam government. They also counterfeited official stamps and seals which they were aware to be false. The true copy of visiting card of the accused number 2 and later a head of the Motok Autonomous Council were annexed to ensure its respective. And paragraph 5, you will see the 5.1. Mr. Kuzdeep Bansal is a professional fortune teller. Jyotish, Mr. Mohit Kalra and Mr. Rajinder Sharma was also consulted Mr. Kuzdeep Bansal, and these interactions over a period of time resulted in a friendly relation. Due to the proximity which developed over a period of time, Mr. Kuzdeep Bansal became aware of the business being dealt by them. Mr. Bansal was also aware that all of them have considerable financial and professional capability to execute a big project, and knowing their capability over a period of time, started coming his proximity to his proximity to several government functionaries with whom he can get them introduced. Mr. Bansal also got to know about the complainant, and after getting considerable information, started to enticing them with a proposal for the government project. And 5.2, on 17/9/2022, Sri Kuzdeep Bansal introduced Mr. Mohit Kalla, Mr. Rajinder Sharma, and Kamal Sabarwal that the government of Assam is looking for a supplier in a bulk goods which includes school bags, blanket, etc. for a project overseen by the CM for the welfare of the people in a various districts of Assam. Sri Kuzdeep Bansal claimed that he has a good contact with the extremely resourceful officials at the top of a whole of the government of Assam can be instrumental in getting the project for them. He claimed the contract value of the aforesaid commodity of rupees 26 crores 66 lakhs, 260 crores lakh 40,000 only. He though WhatsApp also forwarded the snapshot of the requirements of the aforesaid product and image of the approved product previously source of the government of Assam from Moto Autonomous Council. Though other vendors, a screenshot of the WhatsApp message received by Sri Mohit Kalra from Sri Kuzdeep Bansal, save in his phone number Kuzdeep Uncle. Sharing the aforesaid information is extracted herein below the ready reference as follows. 5.3, Sri Kuzdeep Bansal, in order to give further support of his assurance, introduced his brother Sri Harish Bansal. Mr. Kuzdeep Bansal assured that his brother Sri Harish Bansal will manage the transaction from Delhi and will act as a go between all other accused persons so that no glitches and hiccups happen in the implementation of the project. In order to have a seamless transactions and further payments are received without any demur, and he claimed that his brother will work in that regard. He also thought that his brother may give some compensation for his service rendered. Sri Kuzdeep Bansal on 17 September 2022 further claimed that he and his brother Sri Harish Bansal personally known the principal secretary and managing director of Motok Autonomous Council, Sri Partha Bharadwaj. It is now, Partha Bharadwaj is a fake person, sir. It is now evident that Sri Kuzdeep Bansal was the mastermind behind the entire conspiracy, as it was him who was looking for a victim to be defrauded with aid and assistance of the other accused person. Evidently, it was Sri Kuzdeep Bansal and Sri Harish Bansal who claimed to personally know Sri Partha Bharadwaj and also house for his position in the Motok Autonomous Council. Sri Kuzdeep Bansal and his brother.
all your role is specifically.
So my role
depicted.
is there 7 years maximum, my lord. Bail, my lord. I am on bail. I am not on questioning.
No, your bail, if it is a conspiracy,
Yeah.
then it will, if it is a
It-
offense of a life imprisonment,
My lord.
then it will be
No,
abatement will come.
Kwame, there is no allegation that I received any pecuniary benefit. Where is
No.
that, my lord? In order to, expose
No,
me to
no.
those.
He might receive pecuniary benefit not from you. How will you give pecuniary benefit? From the other, the
No,
Bharatdas.
today, Lordship is examining the
No, we are
matter.
examining, we know our limitation in case
So
of.
what I am saying is, my lord, by passing that order in this proceeding, my access to justice has been taken away. What is the remedy available to me now, my? I can't be remediless. Kindly appeal. By passing that stay order in that criminal proceeding, my lord, my access to justice has been snapped. It is unheard of, my lord. It is a different matter, my lord. They could have raised that objection for XYZ reason.
Okay,
This bail
we are
application is not
issuing,
maintaining.
we are issuing a notice on this,
Yes.
and we are taking up the matter whether it is a case where you can be remedied. If we think that
No, my lord, they because of this stay order, I cannot go to anybody.
no, we'll see
I
the
cannot
stay order.
approve
If
that court.
necessary, we'll vacate it today itself.
So all that I'm saying is, I'll, participate in the investigation, but not day-to-day basis. Only thing is, Lordship, considering my, apart from anything else, my health condition also give me some protection. Some protection only. Yes, my lord, law is laid down finality when a finality is given to a decision. At the stage of a motion, my lord, we did not take a lot. So, prima facie,
No,
my
we
lord,
know that, but at the stage of motion, when prima facie case is made out so far related to a quashing, investigation should also not be
No, I'm
shown
not
and
even
forced.
saying-
No
I'm-
coercive acts or orders
for
should
the
also be
present, I'm not even saying in my quashing petition, prosecutor also issue a notice. I'm seeking relief only in my IA, my lord. At least NBW should be stayed or some protection should be given, my lord.
in IA in the other.
Yes,
So
yes.
here we are issuing a notice, will come back to the
Yes.
IA,
Hmm.
right?
Yes. At least no coercive measure, my lord, I'll participate with the investigation on day-to-day basis.
And what is the law, Mr. Bora? With your petition.
No, my lord, can I come to one thing?
Yes.
Now the fact that
What
section
is
2
the meaning of a transit bail?
Yes.
Now, first thing.
Let him say it, then I'll reply.
Second, just I am putting questions to all. Second part is that a record of a competent case, a person is you will say this is an arrest. Isn't it? A person is arrested, produced before a jurisdictional magistrate without anything.
without it.
That is a record.
And my
On
lord,
record.
and my
Just
lord,
ask
when
them.
this
Just-
number, kindly appreciate my lord, when this team came to me, they came with 20 private securities, my lord. The team was not accompanied by any police officer.
No, we'll not go to that fact. We cannot appreciate all those facts right now. We'll have to base our decision on the
Yes.
record. He may say many things. No, this was that. We'll speak
So
in
this
the
is still legality.
order of the magistrate says that nothing was there when it was produced.
Exactly.
Mr. Bora and more particularly not Mr. Bora, Mr. Fukan will have to attend. Number one, suppose court on that consideration says to appear before a court of consequence. Case was registered whether that is a jurisdictional measure.
No.
Okay, fine. Now, his case is that yes, there is no case.
No.
There is no. Now, will it mean that it is an arrest and you have been released for transit in 439 for all meaning? Now, you will file a bail application. That can be decided in the bail application. Why
Also-
should we exercise
Exactly, my lord. That is my
why
point.
should we exercise our power under this?
480.
A notice is issued to be there, will fix a date, raise all these objections.
Yes. And
And-
they have already appeared there from the day one.
So, conduct of police is we are not. Mr. Fukan.
My lord,
No, what generally happens we do not
Well,
know. We want to know what law permits.
one law permit case there is not necessary when a person was. When
Okay.
go
Now,
for a case there is one.
no,
There
now,
the
suppose
contention
a
is that, my lord.
okay, case there is not with this, but something that
No
under
presence of IO. Who will go, my lord? Mr. XYZ.
What is the meaning of a custody? Who will take custody of a person? And what is the procedure? Before whom it will be produced? If nothing is followed, we said all these are illegal. We can take note of this under 482.
My lord, when he was arrested, the police has not, my lord,
No,
note of
forget
that
about
I was
who has gone. We presume that Mr. Soikia went there, arrested him. And what is the necessity of producing him before Delhi? He could have taken directly from his place to Guwahati. Why not?
my lord,
Because it's law mandate that
Yes.
he should be produced there.
Right.
So if law mandates he should be produced there, what is the procedure in producing him?
Exactly.
Whether that has been followed.
Or even
If that is followed, that will be a different view. If it is not followed, that will be a different view.
my lord, that was
And the
followed.
record will have to, we cannot go behind the record.
My lord, correct.
We have no reason to believe the magistrate that he has committed a mistake. He is on record says that IO was not here, this was not here, case diary was not here, person is produced. So in totality of the matter said, okay, we are not giving you the custody. You go there where it is on bail. If his release on bail, till his next bail is considered, he should be outside. Prima facie, I am open to ideas with limited
I think
knowledge.
that's that's not the end of the day, it is all common sense. I think that is the my lord law.
Yes, spoke on. That is his argument. We have heard him. That is his argument.
My lord,
Kindly come to that order. Where is that?
Yes. Order is at my lord, page number 107 of the quoting
That is
At-
107.
and relevant portion is at 108.
1257.
And kindly see, my lord, page 107, what the IO was, that Mr. Saikia, the submission he made was, a cheating case is pending against the accused. Accused is thus required to be produced before Lanet CGM Kamrup Guwahati. No case is pending in this court, my.
No, just one minute for my knowledge. Somebody comes and says that I am a police officer, I have arrested him, such and such. So it's required to produce. Now, no, nothing is to be told, even the
Exactly.
affair.
Right.
Not necessary.
my lord, not necessary, because my lord, I am a police
no.
officer. Why a person can, my lord, civilian can go and my lord, arrest a person and he
Not-
can produce before the my lord.
No, we are not questioning that you are not a police. But will that you are a police officer will give a license to do as per your wish. So what I am asking is there any procedure required when a person is produced? That is what you are.
Yes, there is a my lord provision.
What is the requirement of under law when a person is produced before a court? That is please to us.
My lord, may I say, my
This
lord?
is the order. If you doubt that
If I show the forwarding, my lord, everything will be clear. Come to the page 55.
50
55 of the my lord, criminal petition 1186.
criminal petition,
The Kamal Sabarwal case.
My petition.
okay, 55,
Uh,
Page
my-
one-
page
page 55.
55 annexure 3, my lord. If you go by the my lord, this forwarding, my lord, everything will be clear. My lord, the prayer for transit bail, my lord. What is your page number 50? What is your
okay. So according to you,
My
when
lord.
he was produced, it was the forwarding report.
my lord, Inspector Popular Secretary. Additional I of the case. It is there. And thereafter you will receive a peruse page 61.
Just continue. Now, in CIT cases where he needs to be produced,
And if Lordship, at page 56, your Lordship may see, here, my Lord, they say that they have not given anything, my Lord. Under the, my Lord, after ground of arrest, your Lordship may see, after point number 4. Under the above facts and circumstances, the below noted accused has been arrested after conveying notice under section 50 of the CRP and has been medically examined by the government magistrate. It is completely followed by my Lord, as
no,
per
but
CRP.
that is the supposed it is. Now, if it's a case, CITA case number 20.
My Lord,
Now you see that we need a transit remand
my
to
Lord.
produce him. Produce him before whom?
That, my Lord, where the jurisdictions, my Lord, that Delhi, my Lord,
No.
where he was
Delhi,
arrested.
he was arrested and produced, saying that, okay, we'll have to produce him before the competent court since FIR is registered in such
No, no. My Lord, because he was arrested at Delhi. That competent jurisdiction is, my Lord, the
Delhi.
magistrate, transit bail,
You
my Lord.
produce him before the Delhi,
My Lord.
seeking that, okay,
Yes.
give
Yes,
since he is
yes.
your jurisdiction, give him our custody
Right.
so that we can produce him in the
Yes.
court of the jurisdictional magistrate
Yes.
where he is to be produced,
Right.
which is the judicial court of judicial magistrate that has been reflected in your forwarding report. Before whom you are supposed to put.
My Lord, last para, my Lord. I therefore pay before the honorable court, the arrested accused person may kindly be allowed for 7 days transit remand. I am able to produce him before the judicial magistrate, Chief Magistrate of Kamrup,
Chief Judicial Magistrate,
Yes.
Kamrup, Assam.
Assam.
Okay. Now, so according to you, these CID cases are or in different only in Kamrup. That's
Right.
why I'm asking.
Right.
CID is only for police station is in Guwahati.
Located in Guwahati.
Okay. Then sharing of knowledge.
Sharing of-
And knowledgeable person, those who shares their knowledge gets increased.
And now Lordship may payroll page 60. Page 61.
Page?
Page 61. Annex 4. That is on, my Lord, 2010-23, my Lord. This is an application for grant of transit remand of the accused. Accused has been arrested during the date from so-and-so place, connection with present case. A cheating case has been so-and-so. Accused required to produce learned CGM Guwahati, Kamrup, Assam. At this stage, learned counsel for the accused filed an application seeking grant of bail. Application of bail. It is stated that the applicant is innocent and falsely implicated. The present matter applicant is a reasonable person and almost respect laws and lands. Applicant, I skip this part, my lord. Inspector Prafulla Soikia opposed the bail application, submitting that the accused is deliberately
What is the
avoiding.
bail bond?
My lord.
Bail bond is submitted before this.
Yes.
Where is that?
My lord, the airport. My lord, yes. Kindly, my lord, I may be allowed to complete this paragraph, my lord.
No,
The
that
police-
we have already read, Mr. Chaudhary has.
And page 63 also, my lord. Same is considered accept is so and so.
Whole evidence
Pending.
is put up.
Yes,
That
it is there, my.
accepted. Direction to accused to join the pending before learned CGM Guwahati, Kamrup, Assam within a week
My
from
lord.
today.
My-
Accused is accordingly be released according it's not warranted.
Any other. Everything is followed.
Okay, bail bond finding. Yes. Now, what is page 64?
Page 64, my lord. Page 64 is, my lord, payer for police remand.
Before
Before, my lord,
court.
after transit, my lord.
It is now metro.
My lord, yes.
Why have you stated that it is a Kamrup?
My lord, it is here, my lord. Before the, my lord, that is on 25-10-23. Subsequent.
subsequent which one?
That at page 64, man.
64?
25, 10, 23,
That is
Yes.
the prayer
Of-
for police team.
my lady. Because he is supposed to appear on that
Appear before whom?
before here.
Before whom?
Let me come.
Before
Why
whom?
you are shouting?
Before whom?
This is not your fault.
Before whom?
Because he was supposed to appear, my lord, here.
Before whom?
direction. Because in the court,
No, that's
Jurisdictional
I'm
court.
asking before whom?
the jurisdictional court is CID is to appear because the direction is there. There's a specific direction.
Okay, Mr. Chaudhary, don't keep no running. No running.
Let us, all the juniors are there. Let us
Okay.
follow the.
No, don't go beyond that. Please come to your.
Yes, that's right, Ramesh. Because
Please come to your.
I have,
Come to your.
My
We are
case
here
is that
to-
he
we
was-
are we'll give a patient hearing.
Yes.
We'll
he
try
was
to
arrested.
take our all as palpable.
Yes.
It's not that whimsically we'll go to this side or.
So he was arrested, my lord, admittedly, my lord, and he arrested on the basis of what?
An
On the
affair.
basis of warrant.
Warrant.
So warrant has been procured from the court. So when there is a police case, they are saying the proceeding is pending, the FIR. There is no necessity of the taking cognizance or something. When there is a first there is a registration of an FIR, if the police go beyond the jurisdiction, then he can procure an warrant. And he takes the necessary help from the local police station while arresting. That has been done. So he has been arrested. So if there may be a delay because he can't be taken into the flight, maybe because of this. So there may be a delay because he has to be produced within 24 hours. That's the law. So as he could not be produced within 24 hours within here in the local jurisdiction, so he was produced before the
Yeah,
concern in the concern
that area.
magistrate of that area to take the remand. So at that time the police inspector was present from the order itself. It is expected. Forwarding report also been presented accordingly. That is the necessity. No case diary is necessary at that time. The law is settled. Case diary no. Case diary is only necessary if I ask for when a person is arrested, subsequently he is asked for him, again the police remand. A police remand is granted for 4 days. Then again I am asking for another 4 days remand. Then the police has to place the case diary before the magistrate court.
Our concept, what was how it was put? Now we are
Yes,
satisfied forward
So
report.
forwarding report was there. Without forwarding report, how can it be? A person cannot be taken into.
Now,
So accordingly, they also file a bail application.
so according to you,
That means you has been
that remand is already he is in custody of the police.
Yes.
It is an interim management
yes,
so
So
that
that-
he can appear before the competent court.
or he
So-
can be brought in.
Brought.
Because we can't brought into because within 24 hours we need to. So we may fail. We have to brought in by the other mode. So what is the remedy for the police? They can ask for the remand for making him here beyond it 24 hours. If it is.
That we understand.
Yes.
Here in
So-
this case,
Yes.
the magistrate after hearing the party
Yes.
has
As the case diary was not there,
yeah,
so he has granted an interim
that is what saying.
after arrest. The interim bail was granted. That interim bail was in defined. What is this? This is already person is arrested. It is similar to sometimes Lordship also grants a 439 in interim bail in 49 or 39 also. So the Supreme Court also this kind of interim orders passed in a bail application. It's a continuous judicial custody or constructive judicial custody. He is not released. He is under constructive judicial custody.
Simple fact is that
This man
he was under arrest
Yes.
by virtue of the order of the magistrate. He was allowed to remain outside, not inside,
Yes.
till he
Yes,
appears
he was-
before the jurisdiction
Yes.
magistrate.
Yes.
According to you,
Only remedy was given to you that you by yourself submit before the local jurisdiction, the competent jurisdiction, instead of taking by the police. That is the only difference. So he is under
now what
constructive.
happened on the 7th day here?
So he did not appear.
Then what was what did
Then the police has, on that day also police was, so police on that day they are asking for the custody now.
So that's the application also police, that they need the police custody, because at that time they did not get the police custody. So that is the prayer made by the police for his police custody. Second, now this is a man. So that's why he is a absconder as on date, feeling for the justice. He is absconder because he is now absconded from what? From the judicial custody. He can't seek any remedy, not even the quacking. A person who's absconded from the judicial custody, now he is coming for 438, 482, whatever. Now, I have for the first time I have heard a person inside a custody, he is again asking for the 438. Then so suppose a 439 application has been heard by your lordship and give a person a 3 days.
Understand. Your whole case is, instead of going to the state, that he was out in our custody.
Yes.
But still he is he was supposed to be in our custody, but for the court transit
Yes.
relief,
Absolutely correct.
that within that period of 7 days or on the date 7 days, he should be in before the magistrate, will seek a custody from the magistrate once again.
Oh, he may be granted bail
Also.
So he is not a remedilist. That's a wrong submission, man. He cannot be. Yes, law is absolutely clear. Nobody can be a remedilist.
Now,
His remedy was there.
Can he file a bail application from the outside?
No,
Now
he has to submit.
He has to submit and file an application along with
Application under
439.
439. 37 also if required. 39 also.
So you want to say he's still having a remedy to go
under the
to the
439.
439 and
Or-
file an application.
Yes.
And then court may grant
Court
him
will
even
decide.
interim also, or
Or release
make-
absolutely also.
or
That's
call
a
for
different
the case.
proposition, man. But 439 at any point of time is absolutely barred because of the Supreme Court judgment
in
of
good
the
thing.
thing, para 37, 38, that's the law. And apart from that, my lord, there are two judgments of the lordship. The recent judgment also. This is the similar thing has happened. Similarly, he was granted in their two cases. He was granted a bail, similar to this. Then he did not appear in that
That recent judgment.
recent judgment, very short judgment. He did not appear. In the meantime, he was arrested in another case. So as he has not complied with, he is arrested in some other cases. While he is custody, he has filed an application for 438 again. The Supreme Court said no. You are already arrested. You have violated the law. So now, Lordship kindly see, if it is an illegal, what is their plea of 438 now? What is my understanding? What is their claiming that it was an illegal arrest? Let us take it as an illegal arrest. If it is an illegal arrest, they have to challenge it under 226 for illegal detention, not under 438. 438. 438 under the jurisdiction.
Prayer is not of an illegal arrest.
Yes.
Prayer is for quashing that no case is made out, and this is a
This is a-
abuse of the process of the court.
Yes, that petition
That
Lordship
we
has
are not
already.
satisfied.
So Lordship has already.
I'll give my reply, my
No,
lord.
this part is different. But
Lordship,
that we are prima facie
Prima
reading, we
facie-
are not satisfied.
so my lord, the case is, my lord, my case is that this is not a case even for the notice. Because the prima facie, Lordship only go by the prima facie. Lordship will go by the, not beyond that. Not go beyond that. Here, every paragraph,
Notice will help everybody.
but that already dealt, that help is already been done. That Lordship, that part is already been covered. No,
Yes.
Lordship not needed to worry about that.
Yes.
That has been taken care of. So, my lord, our contention is that, my lord, if the arrest is illegal, what he said, that so my lord, every person who is arrested from the custody, can he file a bail application under 438, my lord, challenging that my initial arrest was illegal? Every person who is in custody, who is seeking a remedy before your lordship, who is in custody, will come before your lordship that my arrest is illegal, so I am again filing the 438. Can it be possible, my lord? Because he has to challenge it, that if his arrest is illegal under 226. And that has to be either if he's got that the state is order is granted, that's a different proposition. But here, that order never been challenged. That remand order, that has not been challenged. He has violated the order passed by the magistrate. So, though he was in a constructive custody, judicial custody, he's violated the order. He is supposed to appear. So, as on date, he's a fugitive pilot. He's absolutely fugitive.
Yes.
So, when he's a fugitive, can he take a remedy under 438, a person already been arrested? His remedy is that the 439.
That will take
The notice that has already been issued. So, where he is, my lord, the lordship here, they file a vacating petition.
No, vacating we are not.
Let them
talking. We are saying that a fugitive is not even entitled for taking a quashing of the affair.
No,
Or
I'm not
whatever.
on that. I'm on this, my petition, because the lordship is already made up your mind that this will be only notice. So I'm not arguing regarding that part, that first petition regarding quashing. As lordship said, I'm issuing notice. We are not on that. And lordship in your lordship's bail order, the last bail order, they specifically said that the lady, his bail order
I have
was
seen the
rejected.
case diary.
Your lordship has seen the case
She
diary, and
herself-
the lordship's
She
order is
herself
very clear.
represented.
Lordship
She handed over the
Yes, yes.
document, everything.
and the lordship order is there very clear. This court finds that the sufficient materials are available implicating the accused in her role in commission of the offense. Materials so far collected suggested the present petitioner impersonated herself to be a government official and handed over the fake oath order to so and so, so and so, so and so. Be honest, the investigator at the very name so and so, and
So therefore, suppose prima facie, why we are saying is that specific allegation is that how he has introduced, description is given like an 161 statement.
Hey,
Like an 161 statement. So
autonomous council at the behest of the prime accused. So lordship already after perusing the case diary, lordship has come to a finding that with the prime accused, who is the prime accused as per the FIR, is present petitioner. And his brother.
prime because it's a part of.
No, and also present petitioner from the very beginning. He is also
Understand, but
our FIR.
his role is depicted in the FIR like 161 statement. You cannot tweak it to 2-3 paragraphs. You can say that it's a clear drafting. Maybe the first paragraph, but subsequent paragraph, how he was there, when he was there.
What
these are
role
there,
is
Mr. Chaudhary.
Mr.
So
Chaudhary?
If my learned kindly give me 5 minutes.
Lordship is in the FIR. Elaborately, the FIR has broadcasted everything. What role is exactly
our anxiety so far relating to other part was that high-handed.
No.
If there is a high-handed action, of course, we can exercise our power and inherent power we can do it.
Then
That
under
everybody should know. Your police also know.
yes, but
Suppose we are satisfied that yes.
yes.
Then
That's what
it
I'm
is a
saying. The
different-
law is clear. So what is when a person can be arrested without even producing him, he could have been brought in here.
Even is not challenged, it is come to our notice that there is a direct violation of Article 21 will definitely not only in this case, in other cases.
That is
It's not that we will have to file for
lordship.
26.
That is lordship will decide. That's a different issue. But my contention is very clear. That in this,
We understand. Your case is that he was already in custody,
Yes.
therefore 438 will not be maintainable. At best, he is not remedialess. He can file an application under 437 or 439.
yes,
And court is at liberty to give him interim, give him absolute. That will depend upon how
Yes.
it is presented,
So,
what are the methods.
and the lordship, I'm just relying the two judgment, my lord.
Stay vacating, we are going to stay vacating or what? We not go to the stay vacating. If we pass
It says that stay vacating, the whole petition will be instructed, my lord.
if we keep relief or not in the 482, not in the stay vacating.
And the only remedy is that my senior officers has argued that it was a cryptic order. If it is a cryptic order, it has to be challenged before the Superior Court, my lord, not here, my lord. And
I have some reservation on that. I'm not saying cryptic, I can say as a cryptic order. But whether that interim order is binding on a subsequent judge passing an order.
That's
Uh,
an expertise.
Maybe, man.
No,
It-
maybe,
Maybe expertise.
maybe,
It has to be, man.
maybe even if it is a final order, no ratio is laid down, that is not binding.
My
We are not
contention is,
sitting over any both
No, no,
order, but
so that order, if they want to
that
challenge
is
it, my
an
lord.
interim order.
So
that
that's
will
what
be-
I'm saying.
That is an interim order.
That's the argument has been made, my lord.
No, he may say it's a cryptic
Yes,
order,
yes.
so it should be
So that's what I'm replying, my lord. I'm not on
to
that.
be
my lord.
vacated. That is a different.
That's what I'm saying. Because I have to argue. I have to reply to this contention, my
No,
lord.
no, you cannot. I think, cannot make a submission that an interim order somebody has argued as cryptic, and interim order, therefore, interim order shall not be vacated by the subsequent judge. It will have to go to that court on.
No, not necessary. But
So therefore, we'll have to reapply
then
our
lordship has
mind. That was an interim order. We'll see it
then
later.
lordship has to decide entirely the petition, not the vacate.
So
See,
therefore,
there is no question of vacating in the 482, my lord. No
we are
question
not,
of vacating in the
we are not
482.
coming to the
Yes.
vacation also.
So vacation.
We are taking this 480 that has come suddenly because of this connection.
No, 482 as lordship has said only notice.
So therefore, we are passing an order here also. Yes.
So, my lord, no, these two applications, lordship kindly, this judgment, lordship kindly.
Okay. One is Jain.
The petitioner was granted regular bail under section 15.
One is Jain.
Yes, sir. Environment Protection Act. Suffice to be observed that the bail has come to be cancelled because of the non-appearance. The proceeding under section 20 of Penal Code ensued, leading to the arrest pursuant to which he was released on bail. The petitioner now seeks anticipatory bail pursuant to the cancellation of the regular bail granted him to under section 15 of this act. The person released on bail is already in the constructive custody, as I said. So he was also in constructive custody. Second paragraph. If the law requires him to come back to custody for a specific reason, we are afraid that an application for anticipatory bail, apprehending
This is
arrest,
one is in paragraph
1 and 2, 1.
1 and 2.
Very short, my lord, only one page. The one page, the second paragraph itself is clear, my lord. A person released on bail, he was also released on bail, my lord, is in constructive custody of law. If the law requires him to come back to the custody for a specific reason, we are afraid that an application for anticipatory bail, apprehending arrest, will not lie. Therefore, there cannot be an apprehension arrest by a person already in the constructive custody of law. So this man, he was initially in the constructive custody. He is absconded, that's a different person, prospective man. But he was directed to appear within 7 days to the jurisdictional court, because CID has the jurisdiction all over Assam, and they have the office here, they have the police station here. So Guwahati court has the jurisdictional court. So he was directed to appear. And he did not appear. And we have filed a petition, the prosecution has filed a petition asking for the further remand in the police remand, but he did not appear. We have also annexed that order, that petition. So that's why, secondly, the NBW is issued. So, rightly,
NDPS issued
by the competent court. Now, how a person who is treated from the judicial custody, he can ask for any relief that, protection is necessary. Under what? No. A person who is treated from that.
Where is that NBW?
That we don't know. They have said that they wanted to stay the NBW. That's the prayer.
They are in this petition.
Their petition. But there's the submission made by him. In I also. So, to stay the NBW, their prayer, paragraph 11. Page 11.
Page 11 of which petition?
IA, they are IA, man.
Page
11.
Huh?
11
IA.
of IA, there IA, my lord,
No,
in
no.
my petition.
In your petition, IA criminal number 1147.
Yes.
Page 11 is something different.
Prayer portion. my lord.
Prayer.
Yes.
Okay.
Stay of the non-bailable warrant issued against the appellant so and so during the pendency of the anticipatory petition. So, that was direction by the court because he did not appear as directed by the competent court while granting the transit bail.
Yes. Yes, Mr. Chaudhary.
So,
Yes.
so my lord, one more thing, my lord. So, Lordship, in my petition, Lordship, now, there's one more contention raised by my lord, senior my lord, that it's a case of 7 years. It's not a case of 7 years. The case was registered under section 468 and 120. And the 468, the maximum punishment is the life. 472 also. 472 Lordship can see the maximum imprisonment for life. So in that case,
The
41 no notice.
punishment will be
The life
for the conspiracy of doing
also, the
that we have
punishment
told
is the same. And there is a specific allegation in the FIR that there is a forgery. There is a counterfeit of the official seal. There is a specific.
That,
And
that
the
is what
forgery
we
is
say that 161 a case is not a case for an intent. Or in for it.
Will take an appropriate during the matter out that I'm not there.
Yeah.
But I'll keep my reply my lord 10 minutes.
Okay.
So when there is a allegation of 472, there is no necessity to give any notice, prior to the error. And 120p is there, allegation is there, the conspiracy, they have conspired together, everything. Even not only conspiracy, my lord, the allegation of the FIR, his actual role is implicated everywhere. What role he has exactly played. It's not a case that he simply introduced, which has been argued.
That we have seen it. You know.
So if that be so, my lord, so it is a case of 472. It's a case of 472, then until or whatever that the notice within the 7 years, not there, not required. The police can, without even the notice, can arrest him and produce before the country. The only dictation of the police was that they have followed rather the more law. He could have brought directly from there, or leaving all these complications. He could have.
Yes,
But
Mr.
instead of that, they have followed the exact law because they thought it probably that we can't produce him within 24 hours. So accordingly, they have produced him in the jurisdictional court of Delhi. They filed a regular bail.
That
They-
we have heard from what
Yes.
they have done. It is we have heard from.
So
Mr.
forwarding
Kumar.
report is there. So
Your
forwarding
case, your as a
no,
informant-
informant I have challenged my lord. Why I have challenged why I have come
that
before this
that
court. That
common
is court.
substance is that bail application is not maintainable. for
Yes,
that- that-
and the AB was not
AB
maintainable.
was
That's why
not
I'm before your
maintainable,
lordship.
and that was not
The-
CD was called for.
So
That
that's
has been
yes.
that has been
So
stayed.
he can't.
Now
he-
they file a vacating
Yes,
application.
my lord.
We'll
So
take
my
it forward.
contention was that my petition that that court doesn't have the jurisdiction at all to call for CD because anticipatory doesn't lie. The moment anticipatory does not lie, we have to show. So why anticipatory does not lie? Because he was arrested already following
No,
the
that-
due
that-
procedure of court law. It's not that the police was not before the court. It's there. Police was before the court. He was produced accordingly.
That we have
Yes, sir.
Yes, Mr.
My lord,
And last one, only one. And the last thing, my lord, regarding that part, my lord, if he says, my lord, his arrest is illegal, my understanding of little bit of law, my lord,
I have already made that argument.
my understanding, I'm talking about my understanding of little bit of law, my lord. I think under these 482, it's not been possible. There has to be a separate application by them challenging that order. That is the legality of this arrest, not in my petition.
My lord, let us go to the fundamental part. That will kind of take 10 minutes time.
By one, we'll finish
Yes,
it and
yes.
we'll dictate it in
I-
the recess.
I'm deeply obliged. The Article 21 and Article 24 give certain guarantee. My lord, for a moment, Lordship will, all right, let us assume that there are materials in the affair. They can proceed. The question is, they are supposed to proceed in accordance with
Law.
Now, because my individual liberty is at stake, therefore, in such a scenario, when my lord liberty is at stake, then the procedural safeguard has to be construed very, very, very strict. In case of any aberration in the compliance of the law, Lordship will invoke your Lordship jurisdiction, be it under 226, be it under 482, the moment it comes to your Lordship. Now, first thing first, my lord, let my learned friend Mr. Pukan PP appear produce before Lordship any document to show that we were asked to join the investigation at any point. Only when, my lord, we are asked to join, we don't join. Then will the question if a non-bailable warrant today, right? Let my learned friend show. Number two, which is that non-bailable warrant pursuant to which I was taken into custody, which is, my lord, they're making false statement. Rather, they're making false submission. Please come to page 61, my of the petition, my our quashing petition. The search warrant has been converted into a non-bailable warrant. Please come to page 61. 13/10/23 order. Case record is put up in view of the prayer of IO, one Nirmal Chandra Biswas, Deputy Superintendent of CID, whereby he has prayed for issuance of search warrant against the accused Kuldeep Singh. Well, this has been converted into a non-bailable warrant. Now kindly come to the next page, my lord. Accordingly, issue a search warrant against accused persons, namely Kuldeep Bansal. No, all along, what was being submitted by both the learned counsel on the other side, rather wrongs and false submissions were made that a warrant has been issued, my for arrest. It is in this light, Lordship will consider my detention and the consequence of. Now, please, for a moment, come to page 1081. Cannot be somebody's, my lord, ego. It has to be in accordance with law. Please come to 108. Submissions heard, record perused. It is seen that no warrant of arrest has been issued against the applicant accused. Inspector Profulla Soikia does not have a case diary and IO is absent to clarify this thing. My lord, will please come to page section 55 of this year for a moment. Assuming, my lord, the officer in charge has deputed some officer, then what is the procedure? In fact, this is the query which your lordship was opposing. What is the procedure to be followed? Please come to section 55. Procedure when police officer deputes subordinate to arrest without warrant. When any officer in charge of a police station or any police officer making an investigation under chapter 12 requires any subordinate to him to arrest without warrant any person who may lawfully be arrested without a warrant, he shall deliver to the officer required to make the arrest an order in writing, specifying the person to be arrested and the offense or other cause for which the arrest to be made, and officers so required shall, before making arrest, notify the person to be arrested the substance of the order, and if so required by such person, shall show him the order. Let them show compliance with section 55. All throughout, they're making false submission. My lord, if these procedural safeguards are denied to me, I think the answer has to be, my lord, emphatic interference in this matter. No matter in what form the petition is before the Lord, because it's a question of violation of Article 21. Liberty of a citizen is involved, where Lordship will definitely give a strict construction to the provisions. No notice to join investigation, no warrant. There is no indication that the officer in charge has deputed somebody or the IO, nothing of this sort. And my other side is maintaining it is not a case of illegal detention. And which is that, my lord, we have made a categorical amendments in our petition, in our application, my lord, that arrest memo has also been, handed over to us, not given to us. So, my lord, now next come, the order says I should go to CGM Kamrup. We went to CGM Kamrup. We found that there is no cases pending. Then what to do, my lord? We filed that anticipatory bail application. Under these circumstances, my lord, when my liberty is at stake, am I not entitled to move the court below? My lord, under these circumstances, this argument of construct, my lord, what my learned friend say, submitted regarding constructive custody as a proposition, I am not disputing. But in the facts of this case, how this principle can be applied? The moment there is a, my lord, aberration in the procedural safeguard is the end of the matter. My lord, there is out and out violation of section 41B, section 50.
So you want to say
yes,
this warrant of
charge warrant.
charge warrant
Yes.
is not a warrant of arrest. So what is the procedure of warrant of arrest?
My lord.
Then what is the
No, since there was no warrant of arrest, no, my lord, since there was no warrant of arrest, so therefore, my lord, they have to follow 55. Now, where is the compliance of 55?
The-
So I am posing a question.
the source that the page
61.
61
Yes.
order
Yes.
says that 2022 has paid for a
Issuance of a search warrant.
search warrant.
Ah.
Now, what is the procedure of issuance of search warrant and procedure of issuance of
Sir,
warrant of arrest? Is there any difference?
78 and 79.
Person.
78 and 79. There.
Yes.
When a warrant is to be executed outside the local jurisdiction of the court issuing it, such court may, instead of directing the warrant to a police officer within the jurisdiction, forward it by post or otherwise to any executive magistrate or district superintendent of police or commissioner of police located in the jurisdiction is to be executed. And the executive magistrate or district superintendent or commissioner shall endorse his name thereon, and if the practicable cause it to be executed in the manner hereafter provided. Court issuing a warrant under subsection 1 shall forward along with the warrant substance of the information against the person to be arrested, together with such document, if any, as may be sufficient to enable the court acting under section 81 to decide whether bail should or not. Warrant directed to police officer for execution outside jurisdiction. When a warrant directed to a police officer is to be executed beyond the local jurisdiction of the court, he shall ordinarily take it for the endorsement either to an executive magistrate or to a police officer not below the rank of such. Such magistrate or police officer shall endorse his name thereon, and such endorsement shall be sufficient authority to whom the warrant is directed to execute the same, and the local police shall also require such officer in executing the warrant. Whenever there is a reason to believe that delay occasioned by the obtaining the endorsement of the magistrate or commissioner within whose local jurisdiction warrant is to be executed, prevents such execution, the police officer to whom it is directed may execute the same without such endorsement in any place beyond the local jurisdiction, in certain situations without an endorsement Now, but what we are questioning,
Hmm.
you are finding fault with us because when we are in constructive custody, how come we have moved and anticipated?
You are
No,
not aware of what is the case.
I am posing a further question. Yes, in a given case, if I am really in a legal custody, then what my learned friend said is absolutely correct. In a given case, where the custody or the initial, taking over or initial custody or detention is, my lord, goes to the root of the matter, then what would be the the Supreme Court has answered. I'm relying on those judgments. And my lord, section 70 is the form of warrant of arrest. Section 70 of the code. Every warrant of arrest issued by a court under this code shall be in writing, signed by the presiding officer of such court and kept here and signature. So, my lord, so far as this procedural safeguard is concerned, my lord, it is adequately provided, my lord. I should be condemned, but after following the due process of. But the moment, my lord, the question arises whether the due process of law was extended or not, then Lordship will have to take a very liberal approach. So, therefore, my humble submission, it cannot be said that, my lord, my application was not made. The issue which my learned friend has raised in the 482 petition, they can raise it thereof before the court will. In fact, which they appeared. They appeared and they, my lord, they can make the submission when CD will be produced. My only submission, my lord, till then, I should be given some protection. Will appear before the learned court. In the meantime, if they want, I'll submit myself for investigation. Only thing is, my lord, till then some protection has to be given. And my lord will kindly appreciate Lordship has already seen. So far as my role is concerned, if at all I have to be, roped in, my lord, it is only by way of a conspiracy. And that is the aspect Lordship knows. It's on the merits of the contention. So at this stage, can it be said that there is a prima facie case to give us some protection? Especially when, my lord, a procedural safeguard has been denied. A charged warrant has been construed to be a, my lord, warrant of arrest. That is how they proceeded. Only if the procedure is not followed, Supreme Court has said, my lord, this is bad in law. I'll just place two judgments, my lord. Read those judgments. On, my lord, quashing petition, Lordship has said, Lordship issue notice, will consider it as a different matter. But here my submission is, my lord, Lordship will delegate us to that authority, let them raise their petition, also raise, till then some protection. Lordship will fix a date. I love that Lalita Kumari, para 94, 2004, 2014, 2014, my lord.
Give a list.
I'll
Give a
give it.
list which are judgment.
2014 2 SCC phase 1, para 94, my lord. I'm reading slowly, my lord. We'll hand over the copy. I'm just reading slowly, my lord. Principles of democracy and liberty demand a regular and efficient check on police power. One way of keeping check on authorities with such power is by documenting every action of theirs. Accordingly, under the code, actions of the police, etc., are provided to be written and documented. For example, in case of arrest, under section 41B, 41(1)B of the code, arrest memo along with ground has to be in writing mandatory. Under section 55 of the code, if the officer is deputed to make an arrest, then superior officer has to write down and record the offense for which the person is arrested. The Supreme Court has reiterated. Para 94 is that, my lord. So which is that procedural safeguard which is otherwise, my lord, available to me has been provided by them. Am I not prejudiced? Having regard to all these things, my submission is on the, my lord, quashing petition which we have filed, Lordship, as our Lordship has indicated, that by issuing a notice, I have got nothing further to come. as far as the IA we have filed, my lord, where lordship will delegate us to the authority, sorry, learned
Good,
session judge,
Very
where
well.
they will also make their submissions, we will also make our submissions. Till then, my lord, either the NPW which has been issued on 27/10 after, my lord, that may be stayed, or lordship will give us some protection so that, my lord, my liberty is not curtailed in the interim. And I also give my undertaking on behalf of our client, my lord, we join the investigation as and when it is required, if necessary on day-to-day basis. And that is my humble sum.
My lord, there's an allegation that we have.
Forget it. Common law should when he
No, that's
We do not take it.
that we have misstated the court and it's
they have not.
the-
Let us not
the-
waste time on who.
Mano,
misstated what. Let us
regarding the
come-
search warrant and the warrant. Search warrant of a person here. It's not a case search warrant for the books or anything. That's a different provision of the 91. This is a search warrant of a person. There's no question of conversion.
So,
What we have asking for, our prayer was what, my lord? We have prayed for a person to arrest so that it has been granted.
not
the search-
he.
Whatever. So, the lordship takes my every word very seriously, but lordship doesn't take every word of the other side not very seriously. It appears to me.
my lord,
Whatever.
I reiterate that allegation that he's again making false statement.
Yes,
Kindly see the order, my lord.
yes, I am saying what.
Accordingly, issue a charge
from the-
warrant against the
Yes.
accused person, namely Kuzdeep so
Yes.
for what? Of the insert 2 charges in house,
Yes,
office, warehouse, premises of the above named
Yes,
accused
I'm-
person to seize the relevant document, seize of articles. What is this,
So-
my lord?
so
My
he
learned
can't-
friend cannot apply. I'm not forced
So-
to make a submission.
my
On
lord,
the
the
face
40
of this,
my lord, the 41, kindly see 41 then. My lord, lordship, kindly see
Yeah,
41
agree.
too, my lord. I can also raise the voice and the said
you
allegation.
were
My lord,
already raising
my
your
lord, my
voice.
lord, kindly
No,
see, my lord, my lord.
We'll say that list before any other.
No.
No, let it be
We'll
list
say-
before any other bench. I have no problem with that.
No.
My lord, lordship, kindly take, my lord, lordship now, let us take it seriously, my lord. 41, my lord, lordship, take it.
No, we'll
41, my
we'll
lord,
take
first.
Mr. Bora.
My lord, lordship, kindly see, there's a serious allegation that I have made a false submission. That let it be cleared, my lord. What I initially submitted, that the warrant has been issued. I have never said that it is a warrant of arrest. I initially from the beginning said the warrant has been issued and in a case of this nature, even the warrant is
You
not
say that
necessary.
warrant is not necessary
Then
because
why
it
is
relates,
the question of the
relates to-
conversion, my lord?
relates to-
41
according to you, it relates to the offenses as such where without
Warrant is not necessary.
without warrant, a person can be arrested.
and
So according to you, that
Yes.
warrant is for searching house and all. He has not been arrested on the basis of that
yes,
warrant.
and apart from that, my lord,
That is your
there is no conversion of the search warrant we have
Will-
converted.
No, that is his
That's-
submission.
Ah.
But the
So where is the
magistrate
falsity,
maybe-
my?
No.
No, that he said that I have made a
Mr.
false
Bora,
statement.
please.
No, that has to be, my lord. That has to be withdrawn, my lord.
Just now,
That
my-
has to be withdrawn, my lord, then.
No, I
That
can
lordship has
withdraw.
to decide.
No,
That
I-
he said that I made a false statement
Nobody-
before this case, my lord.
No.
That's a very serious allegation against me, my lord. That's a very serious allegation. My lord, lordship, my lord, kindly see.
We
the
understand.
40.
See,
Then if lordship understand, my lord, lordship has to put that question.
no,
They ask him to withdraw that.
I'll saying you. I'm telling.
My lord, lordship,
Your case
is my
judge's job is
let
to
me lordship,
understand what you have
lordship said
please,
that you are
please,
not
please,
lordship is not
please.
jumping to it. Let me complete my submission.
Yes.
What is my submission is very clear. In the 41B, there is no necessity for any kind of warrant. That has been very specific because the allegation is more than 7 years. First of all,
So that argument just now I said that this is your argument.
yes,
You need
madam.
not repeat. Yes.
So the second part that I have converted, that I have argued that the search warrant being converted into a arrest warrant. Where is the
No, no,
necessity
you have
of
not
the arrest warrant?
You have no argued. That is he has
That
argued.
not
that it
he
was a-
argued. Along with this said that I have
1-5. We'll
So-
pass this order during the court.
no. And the lordship kindly consider one thing that regarding the 91 and everything, regarding the search warrant, there's a different procedure. And when the court orders a warrant to be executed, there's a different warrant. So this is not a court. We have taken a search warrant for the house arrest, house search. For his arrest, there is no
No,
need for arrest. Another arrest warrant. That's the difference has to be understood.
Sum and substance of your argument is the warrant issued is for the search of house and
Yes.
documents and the for arresting him in backdrop of the allegation level,
warrant
no
is
warrant is
necessary.
required.
Yes,
That's all. That's
then
all.
where is the question of I am misleading the court? That I have, where is the question, my lord?
Not made, my lord, by
That,
my
that's,
learned
the,
friend.
that's the law. That's you said that right now also I have made this
Let us not
submission,
bring
my lord.
law every time.
No,
We are
no, no.
talking about facts.
No,
We are
no.
talking about
You have
facts.
argued that.
Yes,
Mr. Counsel, you said that I have misled the court. I have never argued that.
Let that
My
continue. Let that continue somewhere else.
my lord, my lord.
No, that's my submission is that, my lord, when he has violated, my lord, there is no coercive action, and the coercive action cannot be passed the written order if there is a prima facie case, my lord. As lordship has said, there is a prima facie case in the rejected the bail order, the coercive action, no coercive order, that cannot be passed. There's a written judgment also when there is a prima facie case. If there is a no prima facie case against the accused, then only lordship can exercise that power.
My lord, just final topic. I'm just taking your lordship.
I'm taking
very
the lead,
sorry,
my
my lord. I was never asked to join the investigation. There was only a charge warrant. Now, my lord, by twisting the, all along they were arguing, therefore, but now they can twist their argument. And the public prosecutor also specifically said, in fact, he referred to the forwarding letter. My lord, the forwarding letter speaks about what? Well, why the question of forwarding letter again? Because lordship wanted to know why he was arrested. Then, my lord, they came to that warrant aspect, which was supported by both of them. My lord, what was issued? A charge for what? For charging my premise. My lord, charging a premises and arresting a person is different. Now, why we are saying, my lord, because 255 and 472 prima facie does not, apply against the present petitioner, considering the allegation. So, my lord, when there was no notice, when, my lord, there was
According to you, even if we accept everything in the affair to be correct, your offenses will not be a life in prison.
beyond
Yeah,
7 years.
Beyond 7 years. So if it is
Therefore-
not beyond
therefore
7 years,
41
therefore
notice
you,
is a
you
must.
are require a 41A notice.
Yes.
That is
That
your
was
case.
right.
That is your case.
Yes.
So therefore, there even if an warrant was required to be issued or a notice was to be given.
Yes.
That's all.
Depending on.
Yes.
And my lord, IO was not there, and section 55 violation is there.
I do not think this. The prima facie sometimes you may not require the case diary. Why you require case? That is what I'm saying. In a passing petition, we may examine it, but if it is abused, even the recent judgment has come that you'll have to look into whether it's a what is drafting called some beautiful word has been used.
Which is
Clever drafting by the lawyer in filing FIR. Yes. It's the Manan is there.
Yes,
What happened?
No, you request it.
Obvious. Yes. Query is, see, your situation is this. Admittedly, the method did not proceed to COVID. I have gone all the records. Now, hereafter, when it started the proceeding in the month of March 2023, isn't it? And from March 2023, there are already 4 witnesses examined. And these witnesses, their examination of evidences and cross-examination is not giving us any satisfaction. This is number 1. Number 2, the judgment, what is the judgment? Sir? By my Lord Justice
Ravi Prakash.
Ravi Prakash. In Ravi Prakash, 3 things you cannot ignore. Yes, there is a proposition of law that this is now, according to us, it will be another ground to the section 37 for prolonged interrogation. But when a case is before us, where prima facie we are satisfied on the basis of evidence or the material, that it is not a case where we have a satisfaction that will not likely to be convicted. that what course of action left with us.
But-
And that too in a case where already within a span of from March to this year, 4 witnesses examined. Why we shall not give a direction that within 6 months of
That in that case, lordship what is to hear of the merit of the case. In that case, we have to go by the deposition of the witness.
that we have gone
And-
through because Mr. Mandanan says that we are not going on deposition only on this point. So to balance your right under Article 21, we cannot brush aside at this stage because if you go to the other judgment, until judgment, where it says that 436A will be also applicable in case of a special act. So if we go by that, in your case, your quantity is huge, 109 in some cases, concealed in a truck, where it a possession. These are the things
If
after. So you say that we will not argue on merit. If we not argue on merit, then only on that
in
we,
merit, if lordship was here on that.
no, you do not question of hearing. You say that we are not on merit. Mr. Mannan said.
Yeah.
Mannan said that we are not on merit. We are only on the proposition as laid down in
Ravi
Ravi Prakash. So we'll have, if you want to apply Ravi Prakash, cannot ignore the methods before us and under what circumstances. It is
In
what
merit,
I
there is a
wanted to.
case, lordship.
Huh?
In merit, there is a case. Because lordship order is there regarding compliance of NDPS ACT. And in the lower court also, lordship, that another case, non-compliance of that section after 7 years, lordship, that accused person accused. If if it is so with this case also, in that
So
case,
if you want to argue on merit, then that's not it. This is our view. Because Mr. Mannan said that we are arguing only on the point of delay in the trial.
in that case, another point was also there, lordship, regarding this item complaint submitted within a after expiry of 180 days. That argument also advanced
But-
by Mr. Manna.
No, that is not.
Not before your lordship earlier.
No, it's not. I do not know where.
That point is
Don't make
also,
such kind of stuff.
but lordship, if merit lordship, there is non-compliance of
So
that
if you want to argue on merit, this is tentative, our tentative view. So then if you want to argue on merit, then that's not it. That yesterday's method passed and all. Okay, now come to the other. Just take down some point of law. Just give me the citation. Section 37 of the NDPS Act mandates that a court can grant bail to an accused only after telling the public prosecutor, after after having a satisfaction of twin condition that there are reasonable grounds for believing that accused is not guilty of the offense and that he is not likely to commit any offense while on bail. From the appropriate judgment and the proposition of law, the following principles of law can be called up. Okay. So far relating to the satisfaction of the first condition that regarding reasonable ground, a prima facie consideration is required. Otherwise, a plain and literal interpretation of the conditions under section 37 would effectively exclude grant of bail altogether. Next paragraph. Grant of bail on the ground of undue delay in the trial cannot be said to be fettered by Section 37 of the Act, inasmuch as Section 436A of the CRPC is made applicable to the offences under NDPS Act. Satisfaction. Such satisfaction, such satisfaction which this which this court is required to record should be based on reasonable reading and does not call for meticulous examination of material collected during the investigation or during the trial. Therefore, such satisfaction is to be made, and such satisfaction should be a reasonable satisfaction to the effect that a prima facie look into the material on record shows that accused is not guilty. Otherwise, the same will amount to mean complete denial of bail under Section 37 of yes. Next, Section 36. What is the special provision? Not 36A or
36A.
36A. How many special courts are there in Assam?
There is court, I think,
Because power has been given to
No, power, no. Any special act?
no. PMLA court is there, but the NDPS court one was constituted in Guwahati. It is
Section 36A. A of the Act mandates that the offences under the Act are triable by a special court. In the considered opinion of this court, such mandate of the legislature is to achieve the object that the trial are completed at the earliest possible, inasmuch as the conditions of bail and other provisions are very stringent in nature, and fair trial will be a mandate. Fair trial is necessary to protect the right of a person under Article 21 of the Constitution of India. Inasmuch as in the case of Raghubir Singh Supra, the Honorable Apex Court in no unambiguous held that ingredients of reasonable, fair, and just procedure is a constitutional obligation. On the part of the state, and it is also a duty of the court as the guardian of the fundamental right of the people. Fundamental right of the people. so far relating to the constitution of special case, it is stated at the bar that in the state of Assam, though different session judges and additional session judges are designated as special courts under section 36A of the NDPS Act. However, these courts are also simultaneously taking up all trials under IPC, and in certain cases they are also designated as special courts under other law like POCTO Act, etc. Therefore, these courts are not only taking the NDPS Act, but they are also taking up all the matters under IPC as well as under Special Act. Therefore, in the considered opinion of this court can take a judicial notice that such special courts, in absence of such dedicated special court, the trial is obviously to be delayed. Full stop. Obviously be delayed. Therefore, as Mr. Kyle has submitted that the object of the NDPS Act to control the menace of the drugs shall also not be achieved in the manner that trials are entrusted with the session judges without special court being constituted. Until and unless infrastructures are given, special courts are created in terms of section 36A of the NDPS Act, there is bound to be delay in trial. In view of the aforesaid determination and legal pronouncement, this court is of the view that though the delay in trial may not be the sole consideration for granting bail, subject to the provision of 436A CRPC, the same should be a valuable consideration in considering a bail under section 37 of the NDPS Act. And therefore, such determination is required to be made in terms of the given fact of the case. With the aforesaid backdrop, now let this court examine the fact of the practice. Yes, next, which is the case? Item number.
Before that, Lordship, I want to submit one more thing. Yesterday, I made a mention to petitioner court, Lord. In one DRI case, the year 2013, Honorable Judicial passed a judgment. Before 2013, these are the summon procedures because these cases filed by the official and that are the complaint. That is why for starting the case, they examine the officer and then charge them, and then thereafter Lordship again call for the witness. That delayed the matter. That is why Lordship passed the order on that occasion, Lordship, considering the Thana Singh case. Because of this speedy trial in the complaint case, Lordship, this judgment is for.
Now, what is the relevance of this?
Because speedy trial, Lordship, that why the matter delayed by the NCB and the DRI and customs case, especially not the state. Because this is the complaint case, because that was late. That is why.
No, understand now. What is the judgment of?
That judgment passed because.
No, but what is the ratio of that judgment?
That makes the like this way. It should be considered as a warrant procedure case. Just like that, they can call for the witnesses. They can frame the charge and then thereafter call for the witnesses without examining witnesses. That was the ratio decided in this case.
Now, how is the relevant?
Because of speedy trial. Now they are delayed. Delay reason is there, Lordship, because they are not called for the witnesses at a reasonable time. That's the reason, Lordship.
So therefore, we will go through the facts of the each case. If
The
it is delay on their part, we will.
That is why, Lordship, I would like to place the Thana Singh judgment and one more
In
judgment.
which case?
In my case also,
Which one is okay?
51 Lord.
51 we have already adjourned or what?
No, no, no.
No, 51
Yeah.
there is a problem. Give the 51. See, we have what was the last case? Please the cause this day before it. On 28, we have taken all these methods.
Yes.
Okay. And we asked the public prosecutors and the standing counsel to go through the case record so that they can address in each of the cases. Now, on that day, this matter was listed before another way.
Yes.
This 51.
Yes.
On 28. On 28, this matter was not before this court.
That method, it was all
No, let's not. It was not yesterday. I'm saying about day before. Day before yesterday was 28.
Yes.
On 28, this matter was not listed before. And we said that the matter listed before this court be brought in as by a slip. Okay, all this matter has come. And in this matter on 28/11/2023, matter stands adjourned in another.
because both sides
No,
was
not I'm because I'm saying the fact.
Yes.
I'm not blaming anybody. On 28, it was adjourned and matter was directed to be listed on 30th.
Yes.
Now 30th it has come, but 30th it has not. We have not gone through the record of this case, so therefore we will not take up this matter.
Sure.
Yes, next case. Those matter where we have already gone through the records, we are taking up. 50. Yes, 52. So according to you, in this case, co-accused has been granted bail by Supreme Court.
not by Supreme Court, by this honorable court.
By this honorable court, where is that?
Lordship,
This is bail application 3830.
yes,
52.
Other co-accused granted in bail 3830.
3830 2020.
Bail has been granted.
Right.
Now, what are the materials against him and you?
In this case, Lordship, on the basis of the statement of his accused,
10 copies.
on the basis of the statement of his person who got the bail, Lordship,
Hmm.
he has been arrested in this case, Lordship. And 10 witnesses examined in this case. This person nowhere stated that contraband recovered from my possession. Subsequently, he has been shown.
Where is that? Where is the affair?
In this case,
Where is the affair?
It was
in
City
certificate of
doesn't
the
final.
Okay, final. Where is the final complaint?
It is not been annexed.
Next to it, not an act.
Not an-
Then where is that? When you were arrested?
shown arrested on Lordship.
No.
It is this is
Shown arrested means you were already in.
Yes, another case is there, but it's for NDPS. It is the
earlier. I am in that case also co-accused of the bail.
No, you. What about you?
I am
bail application number 4224.
I am Lordship implicated on the basis of the statement of the person from who got the bail from this court. Only on the basis of the co-accused. He is implicated in the final complaint as Lordship. Paragraph number 38. 36 and 30. And the 10 witnesses at no point of time stated against me. Lord.
What is your name?
My name is Mr. Joker. I am from Guwahati. Lord.
How many witnesses examined?
Out of 14, 10 witnesses examined. Lordship, in this case, one more thing I want to add, Lordship. The seizing officer is right now not appearing before the court, and because of that reason, public prosecutor filed a petition to issue the non-bailable warrants against him, Lord. And it is
Who is PW1?
PW1 is Anil Kuta is a team member.
What is the recovery?
Recovery of contraband methamphetamine tablets, Lord.
That is the
2.1
quality. What is the quantity?
2.1 kg, Lord, from 3%, Lord.
2 kg 100.
From 3%, Lord, not from my position.
What is other?
Other 2% means in name in the final
Hmm.
There the Muhammad Rahanuddin, Wandang Khairan, Arun Maditya, Virender Kumar. Then Peter implicated by Virender Kumar.
You have not been arrested from the spot.
No.
From where?
I have been arrested from the jail, Lord.
He was in jail.
On the basis of the statement of the co-accused Virender Kumar. But now it's sort of
How can you have a certificate that you will not commit the same?
as per the witnesses, certain witnesses that from my position contraband were recovered, and whatever stated.
No, I think what is the section 29? 29 is there.
29. If they have to establish the 29 any relation between me and any conspiracy.
Any material so far?
There is nothing, Lord.
Yes,
As per the same witness.
Section 29, any material?
I have gone through all the witnesses, Lord.
And lots of another thing regarding satisfaction, he was arrested in NCD crime number 19 of 2019. On 30/12/2012, with the 980 grams of same contract.
In this point?
Yes.
Is it brought on record in any evidence?
In this application, they have to file other bill application. It is
Pending.
That matter is different.
No, it's
I'm
pending here.
yes. Bill application number 4224 2000.
Not pen. See, if you are continuously doing that satisfaction is
No, my
awareness.
in this case, there is no allegation that these witnesses have not stated 10 numbers of witnesses examined. They have not stated that I have done this thing. There is nothing, Lord. In that case also, some merit is there. I will explain whenever matter will be listed. And in that case also, after recovery from a person, that person got the bail, Lord. So, should I make
What you say?
What the package judgment करो last week. उसमें से तो फिर तेरी committed the judgment.
But considering the period of detention, is this order challenge?
Here, Lordship, see that out of 14 witnesses, 10 has already been executed. He is involved in another case, the same contract. In this case, he was arrested, on arrest. So his involvement is there. So starting whether it can be arrived. That after release of the bail, he will not commit.
that of the export order Lordship on 29th several cases were handled, and even after that, the person released. second page, Lordship, second paragraph. And third page,
Okay. Okay. We'll pass it. All likely will allow. We'll see. We'll
to the application 4224/2000. Got to be taken.
You want to say both should be taken up, but we'll see the material that anything from any suppose your witness also saying that he is a habitual or there is some
Earlier application, it is this allegation. But 4 times he was that he admitted that he is doing this business for us. That is
we'll see. We'll see. Yes, next case.
my lord, in this case, Lordship, there is a long incarceration. Because in this case, 20 numbers of witnesses cited in the final complaint.
Okay.
He was arrested on 26 2017,
That's the case.
6 year 5 months.
Just scroll it slowly. Arrested on
20. I have read.
Ah.
He was arrested on 26 2017, 6 years 5 months 30, and thereafter final complaint submitted on 19/12/2017.
first payment.
Sorry, but Lordship, first witnesses examined on 25/11/2019, and thereafter Lordship 24
Total cited witness.
20.
Where do you get?
It mentioned Lordship 20 numbers of witness, 20 number of witnesses cited, 8 numbers of witness examined till today, since 2017, Lord.
What is the total quantity?
Total it's the commercial quantity, Lordship, recover,
Quantity of what? Tell us that.
Lordship.
There is ganja of 100 kg.
Yes.
That it is methamphetamine.
Ganja 384.21 kg from a truck load.
For
384.21 kg load
384 kg from truck.
from a truck. The allegation is that they were inside the truck.
You are the driver.
Where the allegation is that
Truck is concealed or non-concealed.
it was a concealed position. It
Concealed
found
where?
back side of the truck load
That side. And
and
then
from the cabin of the truck also.
and possession.
From it is recovered from the cabin of the truck and also from
Cabin of the truck.
cabin of the
Not
truck.
the backside.
Some packet from the back load.
Some back, some cabin.
So in this case, what happened, Lordship, 20 numbers of witnesses cited, 8 numbers of witnesses till today examined. And the seizing officer, who is not in service right now, several times someone issued to him, but till today he has not appeared before the court. And in this case, non-compliance of 52A is also there, Lord. To that regard, Lordship, I would like to stress those not relevant.
If not relevant, why will you fight?
But I have to praise Lordship because
Will not allow any irrelevant judgments to be taken.
Lordship,
As simple as that. What are you saying? You said it is not relevant, I'll cite.
but Lordship, after 7 years of trial, he has been acquitted from that court, Lordship, because of
We
non.
may allow it. We do not know. We'll go through it.
I want to place one paragraph of page 60. No, Lordship, it's very relevant.
Enough, but enough, 6, 7 years.
Will be carrying a huge quantity of ganja which they had concealed in a cavity made behind the cabin of the truck.
That we understand. It's not only concealed. He is aware. Possession is there. But how far? You will aware.
No, that is
Let his sword is above his hand. Let him know that I am convicted. Let him have let him prefer an appeal.
if no, that is there.
We'll have to balance. It's not like that.
And
We'll
Lordship,
see. Yes.
regarding conditional Lordship, I have submitted to judgment.
Huh?
Regarding if you that it not take, then
Give the conditions. Which kind of conditions?
I have to place 2 judgments.
Huh.
So
Where
that
are that bundle?
no, 2 separate judgments in the morning.
But the penalty is also there.
Huh?
Wait, got it.
Lordship, in my also with the Tarun Kumar judgment.
Don't say perit. Perit, you will see what is the reason. Supreme Court says so and so, therefore bail grant. Why? How is the relevance between Supreme Court judgment and your fact?
My lord, 53, my lord, I have been at 54. Yes.
54.
My lord, this one page is my case. This is my case.
Yes.
Lordship, in this case, 10 witnesses in example, we want it left. Lordship may come to, in this case, one accused was get bail by the Supreme Court. Lordship may please to see what it.
Sorry.
Lordship may come to page 113.
Yes.
Page 113. There is petitioner approach for the court.
Page 139.
It may come to page 7, paragraph 7, page 140. Nine.
Paragraph 7.
The matter relates to recovery of zero But if here, Farah Singh was granted bail. He has jumped up.
Who has been granted bail?
One, accused number one, Kumar,
Sena will check.
he is not granted bail. That Kumar Bola Singh. This one will go to also observe.
His bail order is in respect of.
Then all check.
Then all-
Petitioner number 1.
Present,
So it was rejected.
it was rejected.
It was.
No,
I-
that relates to rejection and completion of within 4 months, isn't it?
Yes.
Now, Lord Chief, paragraph 12. Same witnesses examined thereafter. Only one witness remains. Kumar Dawala Singh, he was granted bail.
So after this, where bail is granted, after this 11/5/2023, how many witnesses you have examined?
Lord Chief,
My lord, once they complete that.
total 10 witnesses in exam, only one remains.
Okay.
Now, my
And
lord,
Lord Chief,
there is a factual correction, madam. It is not 10,
it is 10.
or 10.
Lord Chief, may call for the record.
Acha, acha,
If
10,
if
10,
I'm wrong, Lord
10.
Chief, no, chalo, sir, what is the meaning of chalo, sir? Lord Chief, I have not understood. When I'm making summation, it is a right, why do they are making such light?
It should be properly instructed. This is expected from you.
This is the
Go to your own brief. Don't have instruction on the air. We have seen that stuff many a time. Yes, next.
if on Dawala Singh was granted bail, he has jumped up bail. This is my it will be verified from.
My lord, another person granted bail in this matter. Recently, he has never jumped bail. He is regularly attending. That fact also needs to be told, my lord. And here, my lord, twice the High Court directed them. Twice.
We have seen that. How many witnesses, sir? What is this is recovered from your possession?
No, that is what, my lord. On merit, I'll submit it was recovered from the possession of a man who is on bail.
Hmm.
And here I am.
Okay.
Here there are three witnesses, my lord, three petitioner, my lord. From two, nothing was recovered. One is the son of one person. Recovery only from one, and another person who is also dead.
Yes, 54 is okay. You say 57%. Yes, Mr. This is Ahmed's case. Huh? 57 is Mr. Ahmed's case. Huh? Your is 50. Where is the record? Keep the record.
Put the same case, same record.
Fifty-five above the this is the Mr. Ahmed 50.
Yes.
What is the so both are arrested on 8/4.
My arrest was made on 9/4.
Date of incident 8/4. 8/4 you are arrested. Is forward and you 8/4 arrested 9/4 forward. What is the material with the case diary against you?
My lord, here, my lord, Hussein Ahmed Khan is the main kingpin, my lord, who is, my lord, as per the CI.
From the city
Yes.
because
That is relevant, my lord. My lord, may kindly
who is
sir.
Hussein Ahmed Khan's client?
That is, my lord,
Who is
Mr.
Hussein Ahmed Khan's
Anil-
lawyer? You are
Anil-
Hussein Ahmed Khan, Zakir Hussain.
no, my lord,
Hussein Ahmed Khan.
that is item number 57. So here, my lord, your lordship might have marked the statement of Zakir Hussain. The lordship, these are the two
Zakir Hussain is
his plan. He, my lord, Zakir Hussain, my lord, another one, my lord, Sada, and Hussein Ahmed, they are all banking job, my lord, and think this. And Hussein Ahmed is the, my lord, main finance. He bring those, my lord,
he is Zakir.
yes, my lord, he, my lord, this one is Hussein Ahmed. The first, my lord,
You know Zakir Hussain. You are Zakir Hussain. Yes, Ahmed, what you say?
I have marked some of the orders, by
Who are they?
towards
I can say that initially was Ahmed was arrested from in 26 was found. He said mining. And I said that the contraband is not here, that is that Hussein Ahmed did that. So accordingly, police apprehended. Nothing was found from my position. It was found from his driver.
How because it can be at the 30 file, na?
Section
Section
30 is fine,
29.
my lord. And now, my lord, charges is also paid.
Charges frame.
Charges paid.
Now, how when can you complete? How to be burden the court?
So the same time, I can are co-existing. He's trusted. I am behind the bar for more than 1 year. But that I have trusted over to the law.
So I have connected with the
You have NA?
The second page of the
page 70 minutes. Page. That's it. Page 32 minutes.
That is Sarija Banu.
Saribuddin.
Huh?
Sorry, page 32 is type
Page 32.
connected 4.
Next up,
4. Page 32.
Saripuddin. Kala.
Yes, the color. About whom my friend has submitted the
Hmm?
my friend has just submitted about
that see the involvement of other
The color difference is direct in the case. Whole phone record, everything with the color.
Allah and Hussein and Zaki.
no,
And Hussein is the my lord main kingpin.
Hussein is main king. He has that 20 lakh. 20 lakh he invested and these are the peddler.
They are-
His man.
His
But his other man is granted bail. Allah anticipated that. After hearing the learned public. .85 kgs of heroin.
heroine
From whose possession?
is from position of
Allah. He left or that place or what?
he left keeping the vehicle. You get that to the bike and another part of the granted bill by the court below. Of course, he was granted bail. Court bill. Now we are with the trial. Almost. Your 29th was the last day, my lord. So with the start. How long? There was a chapter there. All the NDPS, UTP, they went on hunger strike about a month.
Oh, don't say all this.
Right.
Don't say all.
Well, because of this fact that they want a hardy trial.
my lord. First, my lord, this Hussein my lord, this Allah, because of Allah is
When
not arrested.
prosecution is helpless,
Sir.
we cannot help. That's it. Yes, next. Both all of you. You are happy. You are happy. We shall also be happy.
This matter is related to item 54. OAQ
50.
54. Just first matter.
This is item number
58. Same accused, OAQ in that case. 10 witnesses may examine.
The conduct of the then because Lordship already produced the record. Since Lordship last week has coming to 9
This is Mr. Manan's case.
No. This is another.
This is in this case also Lordship direction was there for months and 4 months. It could not complete that. Still today, wider witnesses are not examined. That actually is there. And a co-accused from contraband recovered, he got that.
Where is that?
That is is similar to item 54. That copy
Item?
that copy
That Mr. Biswas case. Item 54 and 58 together.
58, we have filed our section 40 please to Peru. One paragraph.
In 58,
Yes, sir. Paragraph 4. And that is regard to the contention made in petitioner to the claim made by the accused trial was in continuation that one witness was called on 10/10/23. This stands that there is no infinite delay in trial of the case, the part of the prosecution or warrant of release of the accused.
I had record the DVD things, so I have gone through the record at the audit of the court lot. Since 39
have you marked anything like mark?
I'm not
10 3?
39 2022. There is no witness or
39
39 2022. In spite of the direction of the Honorable Court, Lord,
39 2020. It's a small thing.
and court also make it for last
39. This is item number
58.
58 and 58 along with Mr. Biswas' item. 54.
In this case, I was delayed there for 2 reasons. One, for COVID. Second, for there was court was vacant for COVID.
And I am second is
The court was vacant for COVID.
That because Lordship, my submission is that during COVID, the Honorable Court has the direction in the case to complete the witness within 6 months. Accordingly, trial court tried, but they did not bring the witness. Lord. And the court was vacant for 2 months, 3 months, like that. Lord.
If I submitted in this first case also.
that is the problem. That is what we have expressed in anxiety.
Yes, sir.
That the court
That is the
person will not take leave to burden everything. Not dedicated.
But my Lord, since 39 2022,
Oh,
There
madam, we have taken note of your argument.
Lordship, my submission, one accused, he has already jumped.
that is like,
54. Yes, 59. Who is in 59? Yes, but-
he arrested for Lordship 38 for about 4 months, for 4 years, 3 months. And in this case, Lord,
How many witnesses examined? 4.
4 out of 8, 4 is
Lordship, it is incorrect. Out of 8 witnesses, 6 has been examined, 1 is dead. Only 1 witness remains. One IO, he present before the court twice, but he was not cross-examined and he was not he was asked to go.
Okay.
Lordship may verify-
According to you, well,
Total
Yeah,
8 witnesses were there.
total
8 witnesses were there.
8 witnesses,
6 has been examined.
6 examined,
1 dead
One date that's in the record.
1 dead,
and 1 remains to be examined.
1 remain. And when adjournment taken on 5th?
On 3 grounds, Lordship, I have 1 date, 1/11/2023.
Just a minute. 1/11,
1/11/23, the witness was present. So the record is previous date, so at least order is
you tell us 1/11,
1/11/23. As per my instruction, he was present before the court. And before that, on 3 occasions, he was present before the
which
court.
are that occasion?
Lordship for
Huh?
deputy,
But my information, the contact lawyer, he never takes any adjournment in any case.
record be previous.
Can't we see the order?
Lordship for sometime products are dead.
Huh?
Proper order. That order is not,
Yes.
not updated.
Order. 1/11, no witnesses came, Lord, to my information. Because the
Then I'll,
court is there.
You produce that.
yes, I'll produce the IO.
On last occasion, when the matter came up, the honorable court, he has stated that on 1/11 case, witness will be examined on that day, the matter will be end. And again, that matter was not end on that day.
Only 1 witness is remaining.
Only 1 witness remains.
And in that case, Lordship may pass a direction, Lordship, to complete this procedure within 2. Would like to-
Item number
59.
thirteen 1/2022,
Yes, Lordship.
22/7/2021. Arrested. Arrested. Commercial.
22/7/21.
My lord.
It is 3548, isn't it?
3548.
Yes.
My lord, another reason which is that for which there are delay in NCP cases is this. I'll tell straight from the ground level here. What they do is that suppose there are 8 accused persons. That this A, B, C, D, E, F has to be arrested. They will arrest A, B, C. And they will, the moment they arrest, they keep counting 180 days. Before 180 days, by super proof, they will file a charge. And then they'll place the burden on the court that we could arrest 4. Rest of the 4, you bring. Issue summon and bring. And in that way, framing of charges get delayed, supply of copy get delayed. This is one such case. Your lordship will find many such cases in the NCP, my lord. What they do is that they file, if I may use that word, incomplete charge. Their purpose is to frustrate 167 CRPC by enemy. They frustrate 167 and then they place the burden on the court that you do the investigation on our behalf, you go and bring, then summons are issued, they don't come, and then finally they concede that okay, now you can, my lord, here the split petition was given by us.
So your arrest is on the basis of statement of
But
void.
boy, I'm deeply offended.
Lordship for the allegation. Let him file an affidavit that this
We are not going to that allegation
No.
for the time. We are taking note of, because this
Okay.
exercise is being done. We
Yes.
want to see that in an administrative side also,
Yes,
so that we can have something. I
Lordship,
mean,
it
maybe
is-
in infrastructure or something like that. Not a way. we are not blaming anybody, but state is also having a
Yes, Lordship,
responsibility.
definitely.
At the same time, we'll have to be considerate about their
Lordship, here in this case, Lordship,
admittedly very stringent conditions,
yes, Lordship,
presumption,
Yes.
bail stringent, everything.
Yes,
If
all
you
provisions
put
are-
them in the same line with others,
it cannot,
then we'll have to treat them in the same way like the other.
yes, yes.
That is the simple.
Lordship, here may please to note some date. Here, charge was framed on 26/7/2023.
26.
Yes, Lordship.
Then
Then PW1 was examined on 12/10/2023.
12 PW1.
Only
12?
one witness testimony. 12/10/2023.
12
October 2020. The next was fixed on 9/11/23. Lordship, not in position to address your Lordship about
No.
what happened on 9/11.
Right.
Now, Lordship, I come to page 31
is 31 of
of the bill.
Okay.
This is with regard to allegation against the identity.
Vishal paper.
Not Lordship. Is the buyer paper,
Fire dip.
page 32. After Burma, that he was co-supplier the seized ganja. He was present at the loading time of the ganja seized ganja in the seized truck from Harpur jungle area in presence of arrested accused Muzammil
You
Hussain.
are reading fire dip, isn't it?
Yes, sir.
Page 31.
Page 30.
So it will go to page 32.
Note that. Here, Dev Burma, alias Jackie, was co-supplier of the seized ganja. He was present at the loading time of the seized ganja in the seized truck from Maharpur jungle area in the presence of arrested accused Muzammil Hussain and other loading and seized vehicles further escorted by him to Guwahati along with other arrested accused in follow-up action. Fire Dev Burma, Jackie along with Vishal Dev Burma were met with arrested accused Muzammil Hussain at Maharabari parking and both of them directed to follow them to Maharpur jungle area to load the seized ganja. After arrival of Maharpur jungle area, the seized ganja was loaded in the truck, the seized truck, which was directed by the supplier Bimal De Burma and Nirmal De Burma. Next, Fire De Burma Jackie made contact about location of arrested accused Muzammil Hussain after a call by Muzammil Hussain from Saha Faisal Pasha for loading the seized ganja. Fire De Burma Jackie was made several contacts with the arrested accused Muzammil Hussain and also made several contacts with receiver Manish, alias Manish Kumar, who was to take delivery of the seized ganja at Darbhanga, Bihar, from arrested accused Muzammil Hussain. Fire De
Muzammil
Burma,
was a carrier. It was
Yes.
required from whom?
Muzammil Hussain.
Muzammil
Muzammil
Hussain,
were from truck.
yes, truck, and he was escorting the truck till Guwahati Road. Then paragraph E. Fire De Burma Jackie was made several contacts with co-supplier, receiver and other arrested accused from the seized ganja. The statement of arrested accused De Burma has been recorded under section 67 of the NDPS Act and admitted with claiming that it was with his full knowledge and clear consent he was picking up, possessing and transporting, trafficking, supplying, facilitating illegal ganja for illegal monetary consideration, and also confessed that he also involved trafficking ganja since 2 years. Furthermore, before and at the time of committing offense, arrested accused found close contact with supplier and receiver of or other arrested accused as per CDR analysis. The seized
But
ganja
CTR
loaded,
analysis, his number is not there. Buyer is not.
it is there.
The inadmissible evidence, my lord, which are being written. These are hit by section 66. These are
Lordship,
hit by
every-
section 25
Lord,
of the
Just
evidence.
come to the CTR. We are assuming that the Muzammil,
And analysis
Bimal,
was found.
Manesh,
Lordship,
Vishal,
Lordship, please to
Tyson, and Nirmal.
found that Fire De Burma was in made contact with the following. His number is there. 2 numbers are. He was in contact with his 2 persons. 2, 4, 6 persons. So these are the materials available against him. And he was escorting the truck from which the ganja was seen.
My lord,
I know, Lordship, these evidence are not admissible. But regarding seizure, these are admissible. We will be able to prove at the time of
there
the
is
trial.
no
Lordship.
seizure from him, my lord. I do not know which seizure. Only one thing, my lord, if they were so confident about the confession of the co-accused or my confession, what force on earth their government of India agency, my lord, training people for years? What force on earth prevented them from taking me before the magistrate to get my statement recorded under 164 so that they can have some credible evidence? They don't do it. These are all statements. If these statements are taken into account, my lord, to deny life and liberty, my lord, then tomorrow, my lord, Section 25 of the Evidence Act will have, this is already settled, my lord, I need not reiterate, my lord, one thing has settled. These are not at all admissible.
Now, Lord, we have to.
They ought to have brought them before the magistrate to get their statement recorded under 164. My lord, CDR context, CDR cannot implicate a man under NDPS Act in as much as like if there is a voice interruption, then there is a issue, my lord. They even accept this, my lord. We have not verified them with the record, my lord, because they have given that those will come at the time of trial. But and since when this liberty is curtailed, my lord, will see one witness examined.
Okay, this is item number
60.
60.
60.
60.
NCB is over.
NCP over. Okay. Yes. Sixty-one, 62, we are not taking.
He is in custody for 1 year.
We are not taking.
Yes.
It will be next week. Go through it. 10 copies, go through it. 63.
60.
I have a
Where is your junior?
Here was the date of FIR 5/6/2021.
Now, how total listed witnesses 14.
14.
Yes.
months.
11
How many examined?
already examined 11, my lord.
11.
Yes, sir. And date of first is 17/8/2020. That's the court, my lord.
17.
8/2021. 30 days in time. And my lord, date of third time is 17/12/2020. 1 and my lord, half year. I have got the order sheet, my lord. If you will also go to the order sheet, my lord, nothing is happened. Order sheet. That's 1 point. Second point is on merit, my lord. If you will also go to the evidence, my lord, my name is not mentioned by anyone except this. This cross-examination. He said, I was found inside the room. Whereas there are other evidence I have given at this matter. There are other evidence. Other evidence to show that Peter 8 has said, except one lady of his that is recovered. There are,
Why PW you were also different?
I don't know.
So we will know, we will cross examine.
No, I if he is not produced, it is the duty.
No, no, not even produced.
After that, PWT
So up to witness number 11,
examine.
1 to 11 examine,
He
except 3.
has been examined, but his protective.
My lord,
Who will cross examine him?
I will protect him, but he still produce the.
my lord, I will, my lord, I have gone for the my lord record. He was cross-examined. That I will point out. My
PW3?
PW3, my lord, Ila Kumar. Is the
Ila Kumar is the PW4 5. He is the Malay. He is the police officer. And by the interesting is the in this case, my lord, because that witness official witnesses in the examination, and by the I have found the record, my lord, 52A was not complied, 57 was not complied, 42 was not complied. You look at already the judgment. All three are not complied.
To return that, you are not
Yes, my lord. You look at kindly go to my lord.
hurry.
You are not
Are in very much hurry.
my lord. You look
Yes.
at
What are your grounds?
you look at kindly go to my lord. This everything is there, my lord. I shall read one by one, my lord.
I need not read. I can read it.
Yes, my lord. You
Why should we read?
if you look at go this point, my lord, everything will be there. This is the evidence again. And if he is a
This is your result of midnight, earning of midnight, isn't it? So section 52
Yes, sir.
violation,
Yes, sir.
Then-
52A violation,
42.
42 violation, and violation, 57 also violation. Yep. All three were violated. Right? They can still.
So possession is not established.
They
In
said,
who are the independent witnesses for the
yes, sir, nothing is deputed one.
PW1?
Inhabited by one lady, two male persons, whereas they have arrested the one lady, one male person. Then PW2, I can this fellow.
Yes, but
I,
Yes,
36,
my lord,
he has done.
yes, my lord,
Yes,
from
you
the,
take your
my lord, regarding violation of section 52A, I have flag marks in the case diary in presence of magistrate, my lord. Inventory prepared, sample drawn, everything is there, but I have flag mark. And regarding, my lord, Caesar witnesses, regarding possession, there is no doubt. Caesar witness 1 and 2 clearly stated that in their presence, those, my lord, contrabands were recovered from the tenanted house, my lord, accused number, and from the statement of the accused person, it is also available that from this tenanted house, my lord, both accused number to the present accused is staying there for last, my lord, 15 months and doing
He
all
is landlord.
yes,
Who
along
is
with my
landlord
lord,
PW?
yes, my lord, from PW4, my lord, landlord statement also, my lord, it revealed, and in his statement
Who
also,
is PW3?
PW3
He
is
is
the
my
police
lord.
officer, my
Yeah.
lord, who has filed a FIR, my lord.
Informant.
I mean, one thing.
PW4 is the landlord.
landlord, my lord.
Okay. Recovered is from the house of tenanted.
Yes, yes.
PW4 said nothing about
Yes, 1 and 2 is Caesar witness neighbor, my lord. They have no enmity with the person to inflict them in a case, my lord. And they have specifically stated that, my lord, PW1, I'd like to point out, police seized the recovered containers containing drugs in my presence, and I put my signature in the Caesar list. From which particular place of the house, my lord, police has seized
From
definite-
whom?
From the, my lord, from the tenanted house of the, my lord, accused number 1, my lord, and in which, my lord, accused number 2, the present accused also is staying with her, my lord.
one like
From-
page 36.
From whose evidence this comes that they are the tenant?
From Caesar witness PW1 and 2, my lord.
No, PW1 and 2 stated from this tenanted house I have recovered.
Yes.
Who was the tenant? Anything?
My lord, that is landlord, my lord, PW4, PW4,
My lord, I am coming.
my lord.
PW4, what PW4 says?
Yes, my lord, I will point out, my lord. PW4, my lord. I am so and so. In my house as my tenant. At the time of taking my house on rent, there were two girls with so and so, age Cookie, Lynn, alias Lynn, and she told me that those two girls were her daughters, but later on I could know that they were not her daughters. He also told me that she was serving in the Nagaland police. After about 1.5 months, many people started to visit Ace Cookie, alias Lynn. I told Ace Cookie, alias Lynn,
Lynn was arrested.
yes, ma'am, that if so many people keep visiting her, I will not be able to allow her to be my tenant further. He told me that she was searching for alternative house, and in that way several months passed. One day, one evening, when I went to the terrace of my building, one daughter of my another tenant came running to me and told me that some police personnel had come to my house. So, my lord, the landlord, my lord, constantly, my lord, asking him
No,
to
no,
vacate,
thereafter there.
My name is Lalong Matre.
and told me that some police personnel had come to my house. Then I came to ground floor and introduced myself to the police as the owner of the house. Police personnel entered the tenanted house of Ace Cookie, alias Lynn, and recovered drugs from the house of my lord Ace Cookie. Around 15 days before police searched the tenanted house of the accused, another person came to the tenanted house of the accused and started living with her. And that another person, that is from the statement of the two accused persons, your lordship may kindly peruse that the present.
Hello, wait, that I am meeting the next time. I have to wait. I put at that time of recovery that several person gathered my house. Police thereafter took away the accused certain Cookie leave. Where is my and my lord, other witness PWA said only from that particular dark, the dark state is covered. And many witnesses said, my lord, I have given the list. There are 4 persons, there are 3 persons. So my lord, my secondly, my lord, he said about 52 MI. Let them produce the certificate. Certificate is not available.
Because my lord, from the LCR, my lord, it is available that
Only
only.
thing is the Caesar is there, my lord.
Okay, what is your item number?
Item number 63.
Lal Cohen
Monk.
Mangte. Okay. Then next,
My lord, from the LCR, my lord, it reveals that only search framing order is available in the LCR. Baki others, my lord,
I have
regarding
got the order. I have got the order.
Baki, my lord, otherwise drawing of temple, my lord, preparation, those orders are not
I have
available.
given the order.
how many witnesses examined till now?
11, my lord, and
11. How many are left?
only 3, my lord, and there is no delay, my lord, in this case.
One is the certificate officer. One is the person who not taken my name in one statement, and other is. And if you also want the 50 days,
Habibur Rahman.
My lord, in this case, my lord, charge sheet was filed. Charge sheet was filed on, my lord, yes, arrested on 16/5/22. Charge sheet was filed on 29/7/22 within statutory period. Charge has been framed on 14/11/22. And thereafter, my lord, out of total 11 witnesses, charge sheeted witnesses, what we examined? 2 witnesses have been examined. PW1 and 2, those are Caesar. So this is the progress of the
What
crime.
is the Caesar?
PW1.
What is the allegation against him?
Yes.
According to the prosecution, 2 by suspected near Bodorpur Ghat and present active partners were there, and there from their pocket 5 packets of Java tablet recovered. Their weight lordship 201 grams.
Is it commercial or
Total. It is commercial, but lordship each one have 100 grams. Also 50 grams is commercial lordship. But there lordship 13 Caesar is picked out. Section 50 violated and section 52 violated. Information
where is your note?
lordship
Nothing. From day before yesterday, you are saying that you have to keep that.
date is there. But lordship kindly come to page 12 of yes. Page 11. Lordship kindly have a look at the down below lordship. Only notice that, but it was recovered from their pocket, not in front of any gazetted or OTP. As they did not object, lordship and the lordship in the next page, kindly lordship page 12, first line lordship, 5 small plastic packets from each of the accused parties. So total
Too early.
lordship,
Too early.
lordship kindly have a look at only 2 witnesses examined lordship. So many
Witness
days
is enough for your case. I have seen for the first time that witnesses deposed like this.
Particularly
And
Caesar
that
witnesses.
two e-rickshaw drivers. I have seen their officers, many renowned personalities. I have seen for the first time that witnesses deposed like this. Okay.
An independent witness.
It is the item number?
Section 65.
Yes. Yes, what is your case?
The date of application is 11/20. It was arrested 10/5/2020. Not what case. This petitioner was arrested in a different case from that.
Hmm.
And was arrested 11/12/2020. Some test 2020. This case was charged. Charge was framed. After that, it was granted bail on 10/5/2020. The very opponent in this NDPS case. And subsequent charge was charged framed based on statement of two witnesses. At that specific. So it's the
What is the case ID?
I have my lord, flag mark. Now the stage is for charge page 139.
It is from whose position?
It is from a railway
train.
railway company.
From a railway. How you was inside the railway company?
No, my lord, but so far the statements goes, my lord.
Huh.
All have given the
On
statement.
the date of seizure, he was inside jail.
He not inside yet.
Okay.
He is a my lord. I have seen my lord.
So he has
2-3
released on
persons-
bail on that day, or what?
My lord, he was not there at that time. My lord, he is one of the railway employees.
Hmm.
On that day, my lord, he was not there. But after investigation, my lord, it has been found that the statements and of the other witnesses that he, along with two others, used to carry those my lord,
Where is that?
contraband.
Where is that statement?
Last, my lord, in the city part, my lord, I have
City part. Yes.
city part, I have flag mark. Several, not only one, but several are there, my lord, who state that they are in fact carrying those witnesses.
What is his name?
He
Anil
is
Malaka.
Anil Malaka.
Anil
Whose statement?
This is the statement of the
Babul Malakar.
Babul
Who is
Malaka.
Babul Malakar?
He is also one of
Accused. He has been arrested.
he has been
Babul Babul Malakar is not active. Can I take it to the charted?
3 persons.
No,
Ah,
3 person.
yeah.
Babul Malakar is not one of.
Subhas,
Rajak, another
Here
person called Pandap.
accused are, I think it should be accused, Saheb Rajak,
And
Pandap Kumar,
Pandap
Bola.
He is one of the railway employees.
witnesses are completely different people. No, it's
Saheb Rajak and
Pandap.
Pandap Kumar.
Pandap.
According to this Babul, Saheb and
Anil.
Pandap used to take help of this man.
Because
Except that what are your materials?
these are one statement.
Huh?
These are the and by the one statement is there, my lord. He
So
also
these are
has
the statement. Anything beyond that
by the there.
suggests that this statement, co-accused statement is corroborated by this. Anything? Any CPR, any voice recording, anything?
Uh,
Somebody
Madam.
may say that 50 additional public prosecutor is also involved tomorrow.
But I
He is
my
also
lord,
involved.
at least my lord 14-11, my lord, there at least witnesses, my lord, then it is clear, my lord,
Two, three witnesses, what they say?
for my lord, no, for the my lord deposition.
Let us see whether already
I'm not-
examination started.
No, that not yet started, my lord.
Apart from the
14,
length of the petition,
14,
petition
11,
is not-
because my lord 13-9 charges frame, my lord, now 14-11 is the remand and
So tell me, who is this Babul?
Babul is one of the employees.
He is also
Because-
an accused. If he knows everything,
Yes, correct. That
Not
is why
accused,
my before
he is
definitely
an
not an
accomplice.
because they take the help of him because he is a railway employee.
So how does Babul Malakar
He knows, my lord.
So he is also a railway employee of Babul Malakar. Or either he should be a railway employee, who knows, or he should be a part of this gang. Who is he?
But
No, nothing is there. More name to put. No? These are the people from Lamti. Nothing is there.
In the next page, my lord, there is
More
another
boy,
statement.
Babo
Yes, yes. It says that
So what Babo Ganja.
maybe, my lord.
Maybe these are having
Yeah.
rivalry.
Yes.
He is not giving it there. How will you prove? Suppose this is correct, taken to be correct. Is Babul Malakar statement, suppose he comes and says that he does a business through railway. What are the other methods?
May I take just two co-accused any statements are there? Just city part.
Again, if we go to co-accused statement, then again it's gone to Fancy.
My lord,
And
Tufan Singh,
subsequent
my lord,
judgment it says that bail, in case of bail also applicable.
for that, my lord, I have, my lord, at least I have found one authority, my lord, that it says it, my lord, that at the time of, my lord, consideration of bail, my lord, 161 statement may not be, my lord, evidence, but relevant.
That is relevant, no doubt about it.
If I pay basis,
That is it in a case of NDPS?
no, it's not the case of NDPS.
So therefore,
But
where
my
it is NDPS stringent satisfaction,
Right.
then definitely satisfaction cannot be on
Yes,
this basis.
but it is also a matter of in a special act also.
So there is no such condition like this. That
There
it
is-
must have a reasonable think of
Yes, but
guilty.
there also, my lord,
Presumption is there.
rebuttable
Presumption
there,
is there, but so far relating to condition of bail 37, like
Yes.
rigor like 37 is not there in book.
yes, but I rely on because also in my lord another case that is Alilutin section 67 that is also there also my lord it has been discussed that
What is the judgment? Who says that Tufan Singh will be applicable in bail?
Alilutin it is there my lord, but
Huh?
it also stated that however by going by the circumstances on record at this stage on the strength of statement of Nizamuddin, though restricted later, the matter stands on a defined footing and the section 37 that,
Therefore, there are some other methods. That is
Yes,
why I'm asking,
that is-
except this anything is
that is what just two statement I want to just take the
so it is
yes,
check it, check
yes,
it,
yes,
check it, show it to him also.
yes.
Yes.
There,
Which item number?
there is these two judgments for it.
Yes, Sunday, Monday, Saturday and Sunday will do this. Yes.
Yep.
Earlier put forward for your authority. There are 15 minutes. Page number 5. Page number 5, para 15.
Reasonable, that we have already dictated. It should be reasonable ground. Either way, we cannot go into deep. In for rejecting also for accepting. That we have already dictated that. I think we are not here.
Specific what is just and the rigor
Yes,
that is criminal act is except the arms act is
I'm taking
and criminal act is not, and criminal arms act is not criminal and it's in there.
37 will not apply.
taking
Who knows?
5 minutes time.
Don't argue that. You want to argue that, we'll have to answer it. Who is having with arms and all? How can we believe that man? At any time he may go. There are three conditions. One, we are satisfied. Second, suppose is satisfied. What about the third?
Likelihood of getting convicted. There is nothing
There
against
are
me.
government employee. He is arrested in an armed case. How can we believe this man?
For 5 months.
Don't argue what is not required.
If it is there, I'll take one.
Yes.
Wait, without my lord, the justice permission to say my lord regarding the other cases in your matter. There it is co-accused already granted the bail. Yes, it's the my lord
That is the not seizure in within daytime, nighttime, this kind of.
No, my lord, that is their strict method contention is that my lord, since it is granted the co-accused. My lord, it was
No, I have seen.
it is not a my lord bail order. It is a time. It is a my lord interim bail for 10 days, my lord. In that days they were asked to appear, and thus they jumped the bail, and thereafter non-bailable warrant stood not. Thereafter, after that they appeared. They appeared and charged from the
They
record.
arrested or not arrested.
Uh,
But that order is not interim order. Problem is that
But
it
that is-
seems like an interim order, but bail application disposed of. What will you mean?
my lord, the lordship that so
I've seen that
it is
because they are counted this charging charge during the daytime, nighttime. This
No, my lord.
question theory.
no. It is stated that on the 11th day, my lord, if it is not appeared, my lord, bail, my lord, the order
Can
is
cancel
cancelled. That is there, but they have not appeared. He has not appeared.
within 11.
No,
No, bail cancel.
bail can.
Then
Then, my lord, after that, my lord, the bail was ordered on, I think on June,
so they appeared beyond the date.
on June, my
Hmm.
but again, my lord, since the trial is not proceeding, the non-bailable warrant issued. Thereafter, on August, my lord, 31st August, he appeared and thereafter the charges were placed.
Then he was released on bail.
No, my lord, not released.
He's inside.
He is inside court because that has to be, my lord, cleared from the that after 31/8,
You mark it. You mark it. You mark
there
it.
is nothing.
You mark it. You mark it.
Yes. So I have,
You mark that. If that is so, then
it's very misleading, my lord.
you mark it. You mark it.
Yes. I have
You
marked.
want to say that order loss is relevant
Yes, ma'am.
because they did not comply with that
Yes.
order. Subsequently, non-bailable warrant issued. Then
Yes.
only they appeared.
Yes.
So that that order
Always
has
on.
lost its relevance.
Yes. And
Okay.
in
You
materials
mark
part,
it.
on materials part, there is abundance of materials.
You mark it.
And that is why I am relying on these judgments regarding the relevancy
Yes,
of one.
yes, yes. Yes.
It is good.
Where is that? You have given.
I submitted.
Ah.
For 5% point for 6%. The day I was released without what date contact, I was arrested. Like back in that case.
That file I have given it to you.
Yes.
And that case also you mark it.
Yes,
Yes. Next. Yes.
5 days in date of FIR.
5 days custody is not important. Is what is allegation? What is the allegation?
Ganja was
Ganja seized. For
From
you
both.
tell all this. Tell us that this was the ganja allegedly recovered from my possession or not from my possession. Tell us that.
from the car belonging
From
to
a vehicle.
Vehicle belongs to whom?
they were
Okay, keep the file. Keep the
here, my lord, the progress of the regarding progress of the trial.
Hmm.
Total 8 to 5 already examined. In this case, seizing officer and informant, 10%. In this case, investigator and must not be the same person. Seizing officer, everything has been done by him. 161 statement of cases been recorded by him. He has written his 161 statement by himself and also written the chart sheet of existing IO is there, but IO nothing else is done by IO except inventory. Inventory is section 52 non-compliant because while in inventory before magistrate, the photograph of the sample have to be certified by the magistrate as true photograph, but that has not been done. And no date has been given on the photograph. The photograph and second.
What is your name?
Two persons, Mridul Das and
Muktadul Ahmed.
Muktadul Ahmed.
Lordship, for a seizure list, there is no date and time of seizure. Vehicle has not been seized. This engine number has not been mentioned. 11 packets were seized, but police collectively weighing the same, not individually what was the quantity of each packet. No,
What
it
is
meant
the total quantity
29.389 kg
of what?
ganja,
Commercial quantity.
commercial quantity. First of all, police received secret information from a reliable source of information and Lordship, vehicle was coming from Lokra side. Lordship, PW stated vehicle was coming from Lokra side. Police intercepted the vehicle, but nothing was found on the place of at the place of occurrence. Thereafter, vehicle was taken to near the car washing center, nearby car washing center, but and vehicle was elevated on height by a mechanical devices. Thereafter, extra chamber found. Mechanic open the extra chamber.
You have cross-examined the person. It is not a case that you are not even inside the vehicle. In fact, in the cross-examination, you have reaffirmed the allegation of the PW.
For a moment, tell it PW5.
PW5.
Five.
We have read the PW5.
He has proved the
Even there is no suggestion that you are not there. It is not a suggestion that this is not your vehicle.
No, Lordship,
Independent witnesses say how it was elevated, how it was inside.
We need the
mechanic
floor.
Beneath
opened
the
the
floor.
extra chamber, but police did not record his statement. He is the prime witness. Mechanic.
Too early.
And my learned friend says vehicle was not seized. My lord, may kindly see page
Vehicle has
17.
been seized, but from whom? But owner of the
Oh,
vehicle.
Name is written over. You were driving the vehicle.
What is the seizure page?
My lord, 17.
Page 7.
Lordship, for a moment. Informant and the investigator must not be the same person. He has written his statement by himself.
From the position of
And he
Mukhtar
has
Amin
written the charge sheet also.
and Mridul. From the position of Mukhtar and Amin. Mridul. Clearly written.
What have done by IO?
Item number?
Judgment was accepting the judgment informant and then not negative. It's a fine. Not doing the
That may be irregularity, my lord, not it. And my lord, in
Date
fact,
of
the charge
evidence
sheet has
was
been
fixed
filed
first
by the
date of
officer himself, not by the PW5.
Date. Consideration of charge framed on 211.
What is the offense concept?
Yes. It's informant and carried out. Then date of consideration of charge 211.
Keep a note.
Prolonging the
Then next. Yes, there is.
Lordship, in this case, the Lordship FIR was lost on 29/8/2021. Lordship, petitioner was arrested 29/8/2021. The length of detention is 3 months. Lordship service was filed at 30/2021. Service was framed at 9/5/2020. Lordship, there are 9 as a Lordship, as a third examine Lordship, 6 are examine Lordship. From my position, the contraband was recovered. But this case, there are 4 cases where arrested from a
Why you were arrested?
on the basis of a statement recorded under section
Whose
67
statement? Whose
of the
statement?
NDPS
Whose
ACT.
statement? Where do we get that statement?
There are 4 accused persons who were arrested from a Sonapur on the basis of that.
That's Sonapur people. Sonapur people. 4 parties.
Yes, Lord.
Where do we get that statement? That's why we have postponed this matter, saying that please give flag mark it so that we can edit. Everybody is sitting and enjoying the drama. That was the idea that everybody will be ready, pages will be marked.
Lord. Lordship, case number 13, Lordship. Lordship, in the effect, Lordship, there are 4 accused persons who were arrested from the Lordship on the basis of the present accused persons were arrested from their downtown hospital. And the Lordship, there was their Lordship. And no voice record.
What is your name?
I have one flag mark to 161 statement of the petition.
What is your name? Petitioner's name?
Lordship,
Kamkoji. As per my note, Milord, from the 161 statement, he says that he came for some treatment in downtown. He was staying in a lodge nearby. Then his Lunun then came to him. His friend Lunun. Lunun is the Milord main victim. He used his mobile on the plea that Milord, his mobile was not out of order, so he used. And by that mobile, he contacted the person from. That is the basically. And he is a teacher, teacher of private. So you look
in this Lordship, there is no teacher.
but
And the
I
Why are you arguing?
Yes, Lord.
whether I have flag
You
mark
should understand not only your case, you should answer that what the PP is expecting.
Yes.
Yes.
he is a teacher of private.
Yes.
Okay.
69 we are not picking today.
69, my lord, this is a different case, my lord, not NDPS.
No.
And my lord, the LCR is voluminous. My lord.
No, we are not taking.
The case was registered under IPC along with 1818
We'll take up this matter if today's LCR cases we can take, not other.
This is UAT Act.
But subsequently charge was framed under 13 when this
13 of what?
13 of UAP Act where the Lordship bar of 45 is
Sanction.
No, 43D bar is not.
Okay.
Bar is not there.
Rigor of
Yeah.
43D.
As it is not under 4 and 6 of
No,
UAP.
we understand. We are not taking up this matter because you want to go to it.
Yes, my lord, that is the volume.
I have filed a charge order on
Yes.
this set.
No, this matter. Item number
69.
69.
It is inside
69 and 69. Yes.
69.
All the co-accused are released on bail.
Oh, madam.
That is why Lordship next week maybe.
Which facts are not necessary for me to hear? Why should you hear?
Next week.
Already brain is
Yes, overloaded.
overloaded. And
Yes.
then thereafter we'll say which I am not taking.
Obliged to Lord.
A good lawyer speaks what is necessary to
Obliged.
not beyond. Yes. I know that. What is this?
Teacher from
Yes, they were controller.
Yes. How many days?
My lord,
47
it
days
is
is on
probably, my lord, very bad, my lord. Because,
It
yes, my lord, there are two cases, my lord. A conspiracy between the, my lord, the deceased wife and their parents.
friend.
And also there is another part, my lord, there is also another person, my lord, who or who want
Mr.
to
Monday,
marry, yes, some,
you go to it.
yes, sir.
You go to it on Monday.
Lord,
paper. But I have
No,
given it
there
to
is
the
another.
it to the
Yes. What is your
list
case?
of data I have given.
Okay.
Just the light that I have. The lot to arrested more than 15, 11, 21.
There is a report also, my lord, by the
This what I have given my the lot managed to the PW. 15, 11, 21 FIR arrested on a forward is 16, 11. Then
This
31st,
is what we wanted, Mr. Chudhary.
I only your candidate about that.
This is what we wanted.
Yeah.
The way you have prepared your case.
Yeah.
Everybody was camping in court, no assistance except you. This is what we wanted, so that we can apply our mind. We have made our mind clear.
Correct.
What should be the proposition to consider a bail? We are not outrightly rejecting that period of detention will not consider at all. In case of 37, we'll have to make a balance. We'll have to consider your right under Article 21, the rigor of 37, and on whose fault. See, here is a case PW1 for 4-1, 28-1, 20, not a single.
Not a thing.
Okay. So it is whose fault?
PW1 was examined on 17/6/22.
So,
And,
so that we can pass this order. Had been the case of others, with this order, take
PW2
the brief and do the case. Judge is there to look into each and every.
PW2 is on
14 days
7/10/22.
after
Is for 11/22 to 27/9/23. No, several. There is a report in the LCR also. Report. Otherwise, thing is that
We know that, otherwise we know. But
9,500 यावत प्लेट from both two parties.
it is your what say? Yes, next.
More than 1 year.
Yeah, obliged. Yeah,
No, more than 1 year. I think.
I think we have done our job.
Fine.
Madam, please come forward.
I think we have given something.
That is what we wanted. How many cases they will do?
We did some
You case.
exercise, madam. I told
That
him
will-
you prepare.
that's not possible. They not. No. This just first we'll you are here. We'll can do this. When your case is also taken.
But your lordship has
What-
already
who-
written a detailed order, my lord, wherein all the dates mentioned
Uh-huh.
there. There are few more things I wanted to
Just you
point out.
note it down. Yes, what happened? Have you recovered?
My lord, only one
reconstructed?
thing, my lord, with respect to whether there was compliance of Section 82 of the Code of Procedure, expressed your mind that the law was fault. I'm not aware whether that has come. My lord, keep it in the event. And on the contrary, my lord, subsequent to your lord passing the order wherein your lordship had suspended that order wherein 174A was added. My lord, the next day, my lord, again, the proceeding went on. The CI counsel was present. They did the court anything for whatever happened. And my lord, I am just handing over a compilation. I just prepared it. My lord, only thing what I have done, facilitate and just to expedite the process, because since it's something dragging for years, so it's a bit complicated for every one of us to understand. But what I have done from the start day when this person was arrested, that is on 28th of September 2020, till date, My lord, I have made a compilation. I have made a synopsis of the orders which has been passed.
Hmm.
Now, my lord, those which has been passed before the lower court are in idle, and those which has been done here,
Hmm.
my lord, are in normal fund.
Okay.
Like 19th, the first page, your lordship sees
I've seen
19th
it.
is
I've
the date
seen it.
which is before high court, so that it is easier for your lordship
Okay,
to
give a copy
understand,
to him.
and so that yes,
When give a date.
my lord,
Hopefully, will not be with so much of burden from it.
today your lordship was overburdened.
Yes.
And
We
hats off,
thought that we'll finish it off. We'll by Saturday, Sunday, we'll complete all the orders.
no, hats off to your lordship. Your lordship had done a
Yes.
commendable job.
Did our
The
job.
entirety.
Yes, when?
My lord, before vacation, if it is
Yes,
taken
yes,
up,
no problem.
my lord, may I come back on 19th or 20th, whatever.
Make it 19, not
Let me check my that for 90 no lot.
19.
22 lot.
22nd is the last
No,
date, my lord.
22nd,
Again, my lord,
not
I
possible.
will.
Give around 16, 17, 15.
Then 21st I come back. 21st.
You proposed it from 10.
Let my friend accommodate on 20th.
20 lot.
20.
20th.
Due to positive time.
My lord, may we come at 2, my lord? Your lord fixes that.
We'll
My lord,
make
then
it
I'll take a late flight and my lord, I'll.
it-
20th.
the written note given by the learned counsel for the petitioner is kept on record. A copy of the same stated to be given to the
It's the entire compilation of the orders, both of them.
Yes, and you also think over how to resolve it. Now everything is clear in our mind.
My lord, 4th
It is
is the
good
date,
that
my lord,
I
let
could
them
understand
proceed
Mr.
before the court.
Kotoke something. Yes,
My lord, the first part of the order